Well, good morning, everyone. Welcome to the University of Minnesota Law School. My name is Gina Tan, and I serve as Editor-in-Chief of Volume 104 of the Minnesota Law Review. And I am pleased to welcome you to Minnesota Law Review's 2019 Symposium, Mass Incarceration as a Chronic Condition, Diagnosis, Prognosis, and Treatment. Thank you all for joining us today to engage with this important topic. And a special thank you to our guests participating as speakers and panelists. We are thrilled to have so many leading voices join us for this event. Before handing things over to our symposium editor, Sarah, I just wanted to share a few words about our journal. Minnesota Law Review is a student-led and edited legal publication publishing legal scholarship on a wide range of topics, now for 104 years. We publish 6 print issues each year, in addition to publishing an online journal called Headnotes and predominantly student-written blog called De Novo. As of last year, we also host a podcast featuring interviews with our authors, and we are excited to present an episode on this symposium later in the year. We are also excited to introduce our first online symposium to be published in January, focused on election law as we barrel toward the 2020 election. We are only able to do all of this because of our dedicated, creative, and sharp student editors and staff who put hours into editing dozens of articles and essays, writing blog posts and student notes, and site-checking thousands of footnotes on top of their regular coursework. This journal is the product of the hard work of a very special and dynamic group of people who I am honored to work with and represent. A few thank yous before we get started. First, thank you to Professor Hickman, who serves as faculty advisor for the Minnesota Law Review. To our colleagues with the Minnesota Journal of Law and Equality, another student-led journal at the law school. Thank you to them for their enthusiasm and interest in partnering with us on this event and for coordinating the panel over lunch today. Finally, thank you to Sarah Troutman, our symposium editor, who you will hear from next. Sarah has admirably driven and coordinated today's event and will be instrumental in publishing written work by the scholars we are about to hear from. Her passion for the subject and care for the details are truly remarkable. And I would now like to introduce Sarah.
Thank you. Good morning, everyone. Thank you, Gina. Everyone, welcome again to our 2019 Symposium. We're thrilled to have you all here, and we're thrilled to be hosting some of our leading scholars on mass incarceration today. They will be presenting their own thoughts and ideas in response to the themes in Franklin Zimring's unpublished manuscript called The Insidious Momentum of Mass Incarceration. It's important to note that mass incarceration is a tragedy of stigma, inequity, and inhumanity. And while the focus of today will be legal, we also hope to acknowledge the heavy human cost of these issues. Speakers today concede we are far from solving mass incarceration, but we come together today to leverage expertise in the law to make our justice system work better for our society. I would also like to thank several people who were instrumental in making today occur. Professor Wright's vision for the event, his enthusiasm for carrying it out, and his thriving academic network were what brought this symposium into existence and today bring together this incredible group of speakers. As many of the people in this room can attest, his thoughtfulness and work ethic and passion for academia has brought together these people and ideas into a conversational, engaging, and exciting event. Second, to the many law school professors who will step forward as moderators and speakers, their academic excellence and willingness to take on additional roles and responsibilities are what make the law school a nurturing community for us young lawyers. Thank you especially to Lisa Birch, who single-handedly coordinates several symposia a year, and the Law School Technology Department, which has tirelessly assisted me in pulling up this PowerPoint presentation for starters. And thank you, finally, to the staffers of Minnesota Law Review who are taking time out of their schedules to volunteer today. Thank you again all for attending. I'm now going to invite Dean Gary Jenkins, Dean of the University of Minnesota Law School, to extend his welcome to you today as well.
Good morning. Good morning. Well, on behalf of the faculty, the staff, the students, I'm delighted to welcome you all to the University of Minnesota Law School and to the Minnesota Law Review's 2019 Symposium, Mass Incarceration as a Chronic Condition, Diagnosis, Prognosis, and Treatment. We have an outstanding lineup of presenters, and we are really just thrilled to welcome the various speakers to help us better understand the issues and the opportunities for policy and legal change surrounding mass incarceration. So it's really a pleasure and an honor to welcome you all to Minnesota Law. You heard a little bit about the Minnesota Law Review, so I won't tell you about them again, but I will say that we are especially proud of our law review and the students who run it. And I want to thank all of them, but I especially want to thank Gina Tan, our editor-in-chief, who you just met, and the Symposium articles editor, Sarah Troutman, for their organization, their leadership in executing this event. Will you join me in giving them another round of applause? So the issue of mass incarceration, both its causes and its consequences, connect with many of the challenges and inequities inherent in society today, from the crushing consequences as well as the racial and economic and social and gender biases at play in our criminal justice system and sentencing processes, to the impacts of our immigration system and our political processes are extraordinarily complicated. The United States has less than 5% of the world's population, yet nearly 25% of its prisoners. Even despite recent state and federal efforts and some incremental progress in reducing mass incarceration, there's still so much work left to be done. Our criminal justice system continues to send too many people to prison, and to do so for longer and longer sentences, ripping apart families and communities, and disproportionately hurting people of color. And it doesn't have to be that way. It doesn't have to be that way for us to be safe. And in fact, of course, it wasn't always this way. Even when Alexis de Tocqueville came to the US in the 1830s to study America's then young prisons and penitentiaries, he found that many states were leading the way in administering more humane systems and proportional punishment in ways ahead of Europe. And of course, even more recently, the sharp increases in prison rates started in the 1970s and 1980s, contributing to a range of effects on government spending, on cycles of poverty. Addressing the causes and consequences of mass incarceration is the work of many, including that of lawyers and legal scholars. I'm confident today's symposium, along with the printed volume that will follow, will contribute to our understanding of this critical topic so that we can continue to deal with it in a thoughtful and responsible way. I'm so pleased that Minnesota Law, which is the home to one of the nation's leading criminal law programs and faculties, it's home of the esteemed Rabina Institute for Criminal Law and Criminal Justice, that we can provide a platform for such a terrific convening. I want to thank again all of our distinguished speakers and guests. I realize that a trip to Minnesota in November isn't the easiest of sells, but we're really pleased that you're here today. Hopefully you can get out without seeing any snow. I think I'm going to wrap up because I think I've done my job, which is really just to warm the crowd up a little bit, let the stragglers come in. I think that that's happened. So we're ready to kick off the really important work of the day. So I want you to begin your dialogue. I'm happy to turn the podium over to the faculty sponsor of this symposium, someone who brings so much expertise, so much insight into criminal law issues, a wonderful friend and colleague, the James Annenberg LeVay Professor of Law here, Kevin Reeds. Have a great conference. Let the important work begin. Kevin.
I just want to say a word about the organizing principle of this symposium. 30 years ago, Frank Zimring, our guest of honor today, was working on a book with Gordon Hawkins called The Scale of Imprisonment that has become the classic, the definitive treatise on how to think about and grapple with problems of mass incarceration, although the book was published many years before the term mass incarceration had been coined. So it's big news to find out that Frank is at work on a sequel dealing with mass incarceration for our time some decades later when the magnitude of the problem has only increased. The idea for the symposium is to bring together experts who can talk about the ideas that Frank is working with toward publication of the sequel or the new book. You shouldn't feel badly or unprepared if you haven't read the book. It isn't published yet. It's in the works. And all of the speakers today will be bringing their own ideas to the podium. We'll have the benefit of some of the work that Frank has already done and some of the suggestions that he's formulating for his book when it comes out sometime next year. So this book that doesn't exist yet is the foundation or the platform upon which the event today is based. And I think you're going to get your money's worth as we go through today. So thank you for attending, and I will turn things over to my colleague Maria Ponomarenko, who is going to introduce our keynote speaker, Rachel Barco.
Good morning, everyone. So this is a special treat in my first semester teaching at U of M School of Law to introduce one of my mentors who had a lot to do with getting me here. Rachel Barco is Vice Dean and the Siegel Family Professor of Regulatory Law and Policy at NYU. From 2013 to 2019, she served as a member of the United States Sentencing Commission. She writes at the intersection of administrative law and criminal law, and in particular has done a lot of work bringing to bear the insights of administrative law and institutional design to the problems of criminal justice. And a lot of her work over the past decades has shown all of the ways in which the political dysfunctions around criminal justice and criminal justice policymaking not only have contributed to the problems of mass incarceration, but have also made us in many ways less safe. Her most recent book, Prisoners of Politics, draws on a lot of this work and will be the basis for her talk today. So please join me in welcoming Professor Barco. Thank you, Rachel.
Thank you very much for having me. Give me 1 second to just get set up. And the dilemma of the water. Okay. Well, thank you very much for having me. It's wonderful to be here, and in particular, to be talking about Frank Zimring's book. I first met Frank shortly after I became a law professor. I don't know if you'll remember this, Frank, but it's in my mind quite clearly. So I was in awe. It was a panel at Columbia Law School, and I hadn't been in teaching for very long, and I was going to be on a panel with him. And I was explaining the thesis of my paper, which was that fiscal changes that were happening in the states, I thought were going to bring about some kind of bigger sentencing changes, but why they wouldn't happen at the federal level, because they weren't suffering from the same kind of constraints, and the politics were different. So, I gave my presentation, and then when it was Frank's turn, he said that I was practicing social science without a license. So, Frank, I remain an unlicensed social science driver, but I have never been asked to go ahead and take the wheel again to comment on both your book and I hope mine. And thankfully for me, you do all the hard social science work in your draft and end up backing up, actually, observations that I make in my own book. Which I use more political economy and some of the politics and existing research and data that's out there on mass incarceration. But we reach many of the same conclusions and even come to many of the same proposed policies that could shift. So if a lawyer like me and a social scientist like you end up in the same place, we're either both completely right or hopelessly wrong. But given your track record, I think we're right. So to set the stage for my remarks, I want to start with a central point that Frank emphasizes in at least the draft of the book that I suspect will remain the same. And I highly recommend it because even in the draft version, it's absolutely fantastic. And one of the things he emphasizes is that for all the talk around criminal justice reform in the United States and the emphasis that there's bipartisan movement to get things done, that in fact all the data and trends point to us continuing to live with mass incarceration and excessive criminalization in the United States for the foreseeable future. And Frank explains in the book why there is so much momentum for mass incarceration and reminds us just how modest the reforms we've seen so far have been. So I'm kind of a glass is half empty kind of person. And Frank's book gives me reason to be that way when it comes to criminal justice reform. So although more than half the states have lowered their incarceration rates, which is good, 16 states report an increase in the number of prisoners in 2016 as compared to 2007. Moreover, if we look at the states that have lowered their prison populations, that decrease is actually pretty small when you compare it to the prison buildup that took place before that. So there was an increase of about 77% between 1972 and 1981. But the decrease from 2007 to 2016 was only about 7%. So that's an 11-to-1 differential. So the glass is actually like 11/12 empty if you're really trying to figure out where this is. And the overall decrease was really driven by outliers like California, which was responsible for reducing the number of prisoners, and I'm getting a lot of these stats from Frank's draft, by almost 44,000 people, and the other 49 states combined reduced it only by 38,000. So this is just to give you an outline of how this is not really a story of large-scale change happening everywhere. And what I want to emphasize in my talk today is that it's not a good thing that things are staying where they are, not only because of the human toll, not only because of the racial disparities and the disproportionate impact, but also because this is an abject failure if the goal is public safety and if the goal is maximizing our limited resources in the best possible way. So I teach and write about criminal law and administrative law, as Maria pointed out, and I have always been struck by the contrast between the two areas. So in one space where I teach and talk about things, we value expertise, we value data, we do cost-benefit analysis. We make our policymakers explain why they're doing what they're doing, and they face judicial review to make sure they're not being arbitrary and capricious. And then in the other space, in criminal law, we just let policymakers go with their gut. You know the expression when you're in law school that bad facts make bad law. Well, you know, criminal law is basically writ large, just one example of that. We get policies that are the result of bad facts that are on the news or in social media, and they may feel emotionally satisfying at the time to segments of our electorate who think that these policies are applying to the absolute worst kinds of crimes that they are reading and hearing about. But in fact, these policies often make us less safe in the long term. Because of how difficult they make it for people to successfully re-enter after they've served their terms of confinement, because of the hurdles we set up. So I think the way out of this is to recognize that we need to make criminal justice administration look more like the rest of administrative law. And I think Frank agrees. So this is from a draft. But Frank points out that a truly sophisticated administrative law of crime can lead to a parsimonious and humane penal system. Excessive punishment is evidence, among other things, of bad management. I hope this stays in, Frank, because I agree with it. And I think this key about bad management and bad policies is really central for us to take a close look at, because I think for far too long, the rhetoric, the bill of goods that have been sold to us is that these are the policies we need to make us safer. That's the trade-off. You have to accept this human misery. You have to somehow accept these racial disparities. That's the price for being safer and better off. And in fact, I think what we find when we dig deeper, and I'm going to explain some of these today, what you find is they're actually not good policies if that's the goal. They're failing in that effort. So Frank's book focuses largely on incarceration, but there's a host of surrounding policies as well that share this trait, where they seem to satisfy a retributive urge for harsher punishment, but ultimately represent, in my view, bad management. And in that, I mean they're failing their goal if the goal is to make the best use of our limited public resources. So I want to highlight just a few examples from my book to give you a sense of what I'm talking about. So the opening chapter for me explains a dynamic that we have in criminal law in the United States, which is that we lump together people of really different levels of culpability, and we treat them all as if they are the worst possible offense in that category. And there's lots of examples of this, but in the interest of time, I'll just give you a couple. And I'll start with one that I think people might have an intuitive sense wouldn't be like this, which is the category of sex offender. And I think when the average person thinks about that term, sex offender, they are probably thinking of people who commit violent acts of rape, people who molest children. But if you look at the actual laws that define who qualifies for being a sex offender, you find they sweep far more broadly than that. So there was a Human Rights Watch report, for example, that found 5 of the states require you to go on a sex offender registry if you visited a prostitute. And 13 states will put you on the registry if you urinated in public. 29 states require registration for teenagers who have consensual sex with another teenager. And, I could give you examples of the kind of cases that are particularly demonstrative of how irrational these policies are. 9-year-old plays doctor with a 6-year-old, ends up on the registry. One elementary school child plays a prank on a classmate and pulls down the kid's pants, on the registry. And then the more, there's not as many of those, but they're there. And more critically, what that's dominated by are teenagers who get on registries after they sexted with each other, after they send sexually explicit photos of themselves to each other. What's critical about this is that the sentencing and collateral consequences for people who are labeled as sex offenders, though, are not based thinking about the totality of this category. They're not thinking about the range of different people who are in it. They're not thinking about children playing pranks or people who go to people engaged in sex work or who are teenagers sending pictures to each other. They are set with the worst kinds of crimes in this category in mind. And so what ends up happening is you look around the country and you find there are very harsh mandatory minimum sentences. There are sex offender registration requirements that are often quite severe, often putting people on registries for life, not to mention all kinds of bans on where people can live and where they're allowed to go. So it's not just true of this category of sex offender, it's true of a host of other categories and labels as well. You could look in our laws and find this just about everywhere. So one is, of course, we give collateral consequences to people who have felony convictions because they're all in the category of felons. And that is a really wide category of behaviors, and yet there are very harsh treatments that apply to everybody who's in that category. We sentence all drug traffickers in many places who deal in certain quantities of a certain type of drug, all treated the same, wherever they fall on the drug trafficking hierarchy in their organization. So it doesn't matter if they're kind of a key manager versus they're someone who's just selling to support a habit. Their sentence and their treatment is largely driven by the quantity of the drugs and the type. 3 strikes laws, which you may have heard of, recidivist sentencing laws for people who have repeat offenses. That too tends to be these just really broad categories of people all lumped in together. But the key part of this dynamic is when they are lumped in like that, it's not that the sentencing range or the treatment of them reflects the wide variety. It's very often the case that they are all being treated as the worst among them. Now, this is disproportionate as a matter of retributive justice and thinking about the punishment that people deserve for what they've done. But what I want to emphasize is how pernicious it is for public safety. And I think the tendency might be that people think, well, maybe it's disproportionate as a matter of justice, but, if we give people longer sentences or we treat them more harshly, so what? Don't we get more deterrence that way? Isn't it better for public safety to do that? And what I want to point out is that the research tells us otherwise. So for starters, we've known for a while that it matters far more if for someone trying to decide if they're going to commit a crime, they weigh way more heavily whether or not they're going to get caught. As opposed to the sentence length that they face if they do. And the assumption that more severe sentences are better also just focuses on the period that someone is incarcerated. So if we're thinking about the incapacitation benefit. So on the one hand, we think deterrence, okay, and what we know is really much more important to think about odds of detection than severity of sentence. But then when we think about, but while someone is incarcerated, they're incapacitated, they can't commit offenses outside of the facility they're held, that's a benefit. And it is. But it's important to weigh that benefit against what happens when people get out. And it's important here to note that 95% of the people who are incarcerated rejoin all of us. They're part of our communities. And so we would want to know if their time incarcerated has an effect on them when they come out. And I think there has been a conventional assumption that, it must be really great for that because they're going to be deterred from doing things again, with not enough emphasis on, what if their time while they were incarcerated, though, actually was harmful from a public safety perspective? What if, in fact, being in prison itself is criminogenic? If the environment is such that it makes it harder for people to reoffend? If being separated from their social networks and the people that they love is actually harmful for a public safety goal? And there's an interesting study out of Texas that finds after a certain point in somebody's sentence, each additional year that they serve causes a 4 to 7% increase in their recidivism rate. And that's a really important fact because it suggests that there are these tipping points in long sentences where whatever benefit we were going to get from incapacitation is going to get outweighed by the harms to reentry when people come back out, and what those longer sentences are doing to them. And if you stop to think about it, it really makes sense because longer sentences, for starters, mean there's more people in prison, and so there's fewer resources to go around for everyone. So there's not enough programming for everyone, and it also ignores the fact that people are going to age out of their criminal behavior for many of them. I'll leave it to our expert criminologists to give you further details on that, but this we've also known for a really long time. So we're putting people in prison and we're keeping them long past the point when they would have aged out of whatever criminal behavior they're engaged in. So at a certain point, we have incarceration reaching this tipping point, and it's not going to be associated with a reduction in crime, but an increase. Now, I can't tell you where that tipping point is. I will tell you in my time on the Sentencing Commission, that's what I asked every single criminologist and data person who came before us, and no one's able to actually pinpoint it. But a rational conversation about criminal justice would recognize that it's there and seek to balance these trade-offs between long sentences, that they're just not a complete good for public safety, just the opposite, that in fact they start to have just the opposite effect and make people less safe. And I will point to a couple real-world examples of this that we do know about, where we have seen jurisdictions reduce their sentences and have not seen an increase in crime, right? Which is one empirical way that you could demonstrate that this is true. So one example from my time on the Sentencing Commission is that we lowered all drug sentences, all federal drug sentences in the United States by what are 2 levels in the guideline manual, which in practical terms ends up being about 25 months on average for a person. So, about a 2-year reduction in sentence. And we made the decision retroactive. And that meant that, more than 30,000 people in federal prison were able to go before a judge and get their sentences reduced, and they were released early. Now, what's interesting about this decision is that we made it as a bipartisan sentencing commission with 4 Democrats and 3 Republicans, and we were unanimous. And so in this time in America, you might ask, how could that be? How could you get a unanimous decision out of 4 Democrats and 3 Republicans? And the reason that we were is because we already had data from when the Sentencing Commission had done this in the past. So the Sentencing Commission had reduced crack sentences in 2007. It had lowered them by 2 levels, and we were able to track what happened to the people who got the reductions over a period of 5 years. So we could see, hey, did it matter that someone got their sentence reduced as compared to the people who served their full sentence because the reductions came too late for them to get the benefit? So it was really nice because you could match people that were similarly situated for offense and criminal history, and the only difference between them was that one group got this reduction and one group didn't. And 5 years later, there was no statistically significant difference in their recidivism rates. In fact, the group that got the sentencing reductions, they had a lower rate. And so looking at that enabled the Sentencing Commission to unanimously say, we can do this, and we can feel confident we can lower sentences without a cost to public safety. States around the country have done similar things. We have seen them reduce their sentences and their incarceration rates without upticks in crime. And I am confident we could do far more and not see an increase. So I want to spend a minute talking about how this relates to pretrial detention as well. So you can see from this chart, this is our total number of people who are incarcerated. And if you look in the orange portion there, you see local jails. And in particular, there's the folks who are in jail who haven't been convicted of anything. And at this point, it's about 500,000 people, a little shy of 500,000 people who find themselves incarcerated before they have been convicted of any offense. And here too, if we ask, well, how does that work for public safety? Would that be a good thing or a bad thing? And here, again, just like the story with incarceration and people sentenced after their conviction, if we stop and we think for a minute what it means to be detained pretrial, means that you are likely going to lose your job. Because your employer's not going to really wait around because you've been put in jail. You often lose your housing, you get evicted. You may lose your children, custody of your children, because there's no one to take care of them while you're incarcerated. This is a completely life-altering event for people, even when it's a short period of time. So when people have studied what does it mean to detain people pretrial versus not, they have found that it increases recidivism risk. So it's a parallel story to the one that we see for people who are sentenced after conviction, where they're more likely to recidivate when they're released than the people who weren't detained, and they control for criminal history and offense type. So the idea is there's something about the pretrial detention itself, and they have found that that increase is true both for the risk of more felonies and the risk of more misdemeanors. So this is a risk of felony reoffending as well. And here too, it's just to point out there are costs to these policies that I think are not part of our public discussion, because the public discussion is always just around the person who's released pretrial who commits a violent offense, and someone asks, why weren't they detained? Whose fault was that? Was that the prosecutor? Was that the judge? Who screwed up? Because surely the person should have been detained. And then there's often a push in jurisdictions to change their entire setup of pretrial detention and their whole bail regime to avoid that one case that makes it into the media. And what you don't get a discussion of is there is a real flip side to that. In fact, there's not the news story that says, wow, our pretrial detention policies dramatically increase the risk of future crime because we are detaining too many people. Because that's not a news story. There's no statistical news stories. I would watch that network, but not many people would. And so as a result of that, we get a really jaded perspective on the costs and benefits of detention, both after conviction and at pretrial. Now, another flaw in our approach is thinking about what happens to people while they're detained. And when we think about what makes them worse off, sometimes it's just being separated from social networks and the people that they love. But it's also that we don't make investments in programming. This is a big theme in Frank's, at least in Frank's draft, and I believe will stay in the book too. This is the awkward part about talking about a book that is not in its final form, but I feel confident it'll stay in there as well, which is this idea that it's really important to ask what happens to people while they're incarcerated, particularly if we're not going to be reducing these populations anytime soon. It should be a real focus of our reform efforts to ask, what are we doing while they're in there? About 85% of the people who are incarcerated have a substance abuse problem, and yet about 11% of people get any kind of treatment at all for that. We see the same thing if we ask about other categories, like people with mental health needs and whether they're getting mental health treatment, cognitive behavioral treatment, vocational training, educational programming. These interventions are cost-benefit justified. They work. They are good investments. If they were on my administrative law side of the ledger, they would all be upheld as good public policy interventions. But we don't do that. We're not doing that. And instead, less than 10% of people who are incarcerated are getting this kind of programming, even though these would be good investments and we would save far more money by making the investment because of what it would mean for reduced recidivism later and lowering incarceration. We also don't do other things when it comes to confinement that as a public policy matter would make sense, that aren't so much about programming, but are just about the way that prisons operate. So for example, we often put people far away from their families and their support networks. But that's a terrible idea if our goal was public safety. We want them to be near their communities, their families, the places where when they come out, they're gonna get jobs. So putting them far away is a terrible public policy idea if that's our goal. Similarly, we want them in a place where people can easily visit. But we are making it hard for families, particularly families who are poor. They're disproportionately poor. These visits are tremendously difficult for people. We make phone calls expensive, even though that policy also is terrible as a public policy matter. We would want calls, frankly, to be free because keeping people connected is really valuable. So we might ask, well, if these are all such great ideas, why aren't we doing them? Well, one reason is that prisons are not held accountable for any of the outcomes that happen after people leave their custody. We're not evaluating them to say, hey, how'd things work while they were with you? And then what happens to people later? And so when they're doing their own cost-benefit analysis, that's not really a key part of what institutionally they're focused on, right? So when they're thinking about things like prison phone calls, they're thinking of, one, they can actually make a fair amount of money from their cut of charging people for calls. And two, they don't like it when some of the calls, not all the calls are good calls. And so, some of the calls could be calls to engage in criminal activity. So they have to monitor those, right? They'd have to have a mechanism in place to monitor them. But they only focus on those things when they're making their policies, and they're not thinking about this trade-off, which is good for the rest of us. That's good for the public because on net, charging people for calls, one, does nothing to help with the monitoring. It just means there's fewer calls, but it doesn't mean that the people who can somehow afford to pay for them are less dangerous than people who can't. And it's also the case that when prisons and prison officials are making decisions about other things within their four walls, that they are really focused on the here and now for them. And it's not that they're engaging in bad faith, and I'm not suggesting that. I think this is just basic human behavior. So if someone is misbehaving in front of them and they think, well, solitary confinement is a disciplinary tool that they want to use because it helps them maintain order at the moment, they're going to think about that, and they may not be thinking about the fact that putting someone in solitary confinement, in addition to just being really indescribably cruel and the damage it does to them, that damage lasts when they come back out. And so it's very hard from a readjustment perspective. But again, the official might not be balancing that out. So when we think about a setup like that doesn't really hold prisons and their administration accountable for how their policies affect people when they come back out and rejoin society, we shouldn't really be surprised that they're not focused on it and that we have really abysmal recidivism rates for people when they come out of prison. with more than 70% who are released have new arrests or convictions within 5 years after they come out. And I don't think we should expect much different if we're not evaluating them to try to get those lower and to try to have that be a more positive intervention. Now, the reason that doesn't happen is because I think there is a tendency in our society to just blame the person. Well, that's not the prison's fault, right? That's the fault of the individual who comes out and decides to commit a new crime, or comes out and decides to keep taking drugs. And if we see this as just a problem of personal responsibility, we never ask how prisons are doing, because we just think they're kind of just like place that the individual goes and then the individual comes back out, and it's all the individual all the way. But that is a pretty strange way to view a massive government program of intervention. This is really, if you think about government programs, you would be hard-pressed to find many bigger than our use of prisons and jails. So this is a massive government intervention on an enormous scale, and we should be really asking government accountability. Are you doing a good job when you're doing this? Are you making things better? Are you making things worse? And I think, we have gone away from that because in part of this turn away from seeing the notion of rehabilitation as possibly being something that could happen. I think that is definitely something that occurred in the 1970s, 1980s, this idea that, well, things aren't working very well, the interventions aren't working very well, and then that led to policy changes that reflected that sentiment, that really nothing works to rehabilitate. And so what you end up is a focus on facilities that are really just warehousing people, and it has other effects as well. So it leads to this idea not to really ask what are the interventions in prison, but it also means we lose a lot of the second looks of people themselves over time, because if you don't think that people can change, if you don't think that that's possible, then you don't need to look at them as time passes to ask if they have, right? And so that also explains why we've seen a decline in parole, why we've seen a decline in clemency, and other second look mechanisms. So I'll give you one example of that that I think proves this point pretty well, because there was a lot of talk about President Obama's clemency grants, which I was quite grateful for, that he granted as many people clemency as he did. But if you look at what he did in historical perspective, what you notice is his overall grant rate didn't even exceed Ronald Reagan. And President Nixon had more commutations than President Obama did. So although he talked about having more numbers, commutation numbers that were higher than other presidents, actually his rate was fairly low. And you see that better here when you see how many people he denied, which is more denials than any modern president by a mile. Now, is that because one would think you needed to deny more people because the overall population of those incarcerated was somehow worse? Yeah, I would argue just the opposite. We had expanded it so much to cover people who had committed drug offenses and who were there serving mandatory minimums, where the judge really was not able actually to give the sentence that they wanted, that if anything, the rate should have gone up. But I think part of this is just this political environment that it's risky for any executive to give clemency, because they too don't want that news story about the person that they give it to that ends up on the news, just like the bail story. So, the one case going awry is a common theme in criminal justice. Now, in administrative law, we don't do that, right? We're not supposed to do that. We are supposed to kind of rationally say, okay, the vaccine has, this rare outcome in some cases, but overall, there are enormous public health benefits. We should do it. Air travel, there may be an accident, but overall is enormously beneficial for society. And so we try to figure out how to minimize risks while keeping the overall approach, which we know to be beneficial. But in criminal law, we don't do that kind of balancing. We let the outlier case drive what we do. And weirdly, it means that criminal law ends up being kind of oddly frozen in time as well, because we make these decisions about people, and sometimes we give them decades-long sentences, 30 years, 20 years, and don't reevaluate them, even though it would defy everything we know about human nature to think that those people and their attitudes may not have changed. Or, for example, that we as a society may not have changed how we view particular crimes. If you even just think about the changes in perspective on marijuana over the years, I think it becomes obvious that you want to take second looks at things and reevaluate. But we have created an environment in many jurisdictions in the United States where that just isn't in the cards for folks. There's not going to be a second look. Even though we might have an initial panic over a kind of crime, we put the policy in place, we don't get to revisit it, and the politics of this make it very hard to do that. So we've seen parole either disappear or decline dramatically in jurisdictions because of single cases of a parolee committing an offense. We've seen the decline in clemency, in good time credits that people can earn while they're incarcerated, compassionate release, retroactive adjustments. And just to give you historical perspective, it wasn't always like this in America. We had 70% release rates for people on parole in the United States as recently as the 1970s. Clemency was a routine thing that governors and the president had given before parole came on the stage to essentially replace it. So between the two of them, we were actually giving lots of second looks in our system. All right, so one more example that I want to give you is collateral consequences, because I think you'll see the same dynamic there as well. So there are, upwards of 47,000 collateral consequences on people who have committed crimes. And they range from making it more difficult for people to get housing and licenses, to restrictions on voting. There are just a range of things that happen to people after they have been convicted. And there are about 19 million people who've been convicted of felonies in America. So these are affecting an awful lot of people. And I just want to focus on the fact how so many of these things make it very difficult for people to successfully rejoin after serving terms of incarceration and stay on a path of law-abiding behavior. So take housing. Okay, so housing is a crucial need for people who are released from prison. So a third of the people who are released from prison are homeless within 6 months. And yet Congress has passed very strict bans on access to public housing. And some of the harshest target people who are engaged in drug trafficking. So if someone in your household is selling or using drugs, even if they're not doing it in the public housing itself, they're just doing it someplace, your whole household can be evicted. And if we think about how hard it is to stay on a law-abiding path when you don't have a home, how much more difficult is that to go get a job? It makes everything harder. Similarly, Congress, when it ended welfare as we know it in 1996, it said to states that they had to impose lifetime bans on people with drug-related felony convictions from either getting federal welfare aid or food stamps. Now, states can opt out of this. They can opt out of the lifetime ban, and some have done so. But people with a felony drug conviction in America are still fully or partially excluded from food stamp benefits in 30 states, and in 36 states from welfare assistance. Again, this is transitional aid that really helps people make the transition into employment, but it's setting up a hurdle in their way. Congress also created additional incentives for states to create more collateral consequences. So it passed a law that said states would lose 10% of their federal highway dollars unless the state passed laws to revoke or suspend driver's licenses of people who had been convicted of drug felonies. So here too, some of the states have decided the money's not worth it, but it's still in 18 jurisdictions, which account for 48% of our country's residents, there is a ban on a driver's license. Now, when you go look, if you have this drug felony conviction. Now, in a majority of these jurisdictions, there are no more than 2% of the workers are able to rely on public transportation to get to work. All right, so if you think about what the situation we've just set up for these folks is, they then have to decide, are they going to drive on a suspended license? There's no public transportation option. So maybe they can't get employment. So what are they going to do? We're making it really, really difficult for people to re-enter society and make transitions to law-abiding behaviors. And again, note we're going to lump all kinds of people together in for these consequences. That dynamic exists for collateral consequences as well. There's many, many examples of these. I just wanted to give you a flavor of some of them. So the next key question is kind of why do we end up with this result if they're so bad? And I've already alluded to some of the political dynamics that create this. This is a system that's not really the outcome of rational reflection, but really by dysfunctional politics. And as Frank notes in his draft, the cumulative effect of this is that we end up with mass incarceration. So when we look at how this all happens, I think one of the really important themes in his book is this idea that, it's not that there was one central planner that did this. It wasn't that it was that. Instead, we have lots of pockets of discretion in American criminal policymaking. Prosecutors have discretion, judges often have discretion, governors, presidents to exercise clemency, parole officials, lots of actors with discretion. And what's interesting is how basically the political climate creates a situation where those actors choose to exercise their discretion in a way that leads to enormous punitive consequences for people, and in particularly prison. Because Frank's book notes that it's not that we see a general trend to creating new crimes or increasing minimum or maximum punishments, but it's this kind of dynamic of how people are letting the politics affect their exercise of discretion. So what does that? What creates that kind of political environment that leads people to do this? So we do have a political process that is focused on particular stories that get a lot of attention in the media. And if you study what the media covers, you find there's a pretty steady drumbeat of offenses involving the most violent cases that make people really angry, or they'll talk about, if they talk about sentencing, it's a focus on sentences that are too lenient, so that people get upset about that. Politicians know that's what's being portrayed. They also know that they can drum up support for themselves and get attention if they point out that there's things that people are afraid of or that make people angry. And in addition to the fact that elected officials do this, we now have a group of people that have a stake in keeping punishment the way that it is, a financial stake for some, because they are bail bondsmen and they don't want to lose the ability to continue to have their industry operate if there's pretrial detention reform, or they make money off of prison phone calls, or they have a professional interest that's maybe not strictly speaking financial, but it makes their job easier to have certain policies in place, which is certainly true, for example, for prosecutors, whose jobs are tremendously easier if they have mandatory minimums to threaten people with and longer sentences if someone were to decide to exercise their trial right. So you have all those folks with a stake in maintaining punitive practices because of how helpful they are in doing their job. And that creates a dynamic that makes it very hard to dismantle because of a dynamic that gives everyone the incentive to keep things where they're going. And it all starts from a public mood that sentences are too lenient because they are thinking about the cases that they're seeing. And here there's information in Frank's book that talks a lot about this, that there are people who have this view that sentences are too lenient. There's studies that show this view, though, is not tied to people who live in areas that have high rates of crime. So the sentiment is not like it's related to higher crime rates, and that would explain some of the things we're seeing. They just have a general sensibility, which I do think comes in part from how things get covered in the media. So this mood that things are too lenient and how people view sentencing doesn't vary, even while crime rates do. And so it's not the case that either public mood is tracking crime rates, nor is it the case that our incarceration boom is tracking crime rates. The incarceration boom may track this popular perception that things are too lenient and all these groups that want to have harsher sentences, but that is also not tracking crime rates. So it's not the case that this is tied together in that way. Instead, there's a political dynamic that's working here about how people are thinking about crime, even if it's not borne out by actual statistics. So Frank's book reminds us it's not just the public that thinks that sentences are too lenient. It's really interesting, I think, that he points out that the group of people who go into prosecution and law enforcement really have strong views on where sentences are. And that matters for a few reasons. So one is it's really important to know how your district attorney, people who are prosecutors, are really critical lobbyists for punishment policies in America. Their thumbprints are everywhere when you look at almost any law that affects criminal punishment. They either directly as a district attorney or part of a lobbying association of district attorneys, they are almost always in opposition to any kind of sentencing reform. We're seeing it play out right now in New York, where we passed bail reform, which is going to kick in January, and they are sounding alarms all over the place about how bad this is going to be. Now, they have no data, but they are talking about individual cases. They're using anecdotes. They're using the same playbill that I'm sure you all know well. I'll give you an example, not from New York, but it's one of my favorites. This is from a district attorney in Lancaster County, Pennsylvania, who, as it turns out, he had his own misbehavior. But before that happened and he got in trouble of his own, he was pushing for longer sentences for people who were selling heroin. He wanted to have much higher sentences in state prison, especially for repeat offenders, and he advocated for this, and now I'm going to quote him because I like this quote because it's so honest. He said, "Why? Because I'm pissed off and we need to do something about it." I actually think that's one of the more honest sentiments about how we ended up with where we are, is someone's pissed off. They think something's too lenient. They're mad about a crime they have just heard about, and they think we need to do something about it, and the something is a longer sentence. It's an expansion of some collateral consequence, and it makes it seem like they're doing something about the problem, and no one is bothering to ask, does that something work? Is that the best thing we could do? And in many cases it's not, and it ends up being ineffectual. But it creates a political environment where it's very hard to be on the other side of this. So what you end up seeing from this political environment is our institutional backgrounds and structures in the United States have changed over the decades. Because, although a lot of this was sparked by an initial rise in violent crime and a legitimate concern of people that we had to do things differently, what I think is valuable, among the many valuable things in Frank's book, is kind of how that then takes on a life of its own, though. So, you kind of initially respond to an instance of higher violent crime rates in the 1970s, for example, and 1980s, but you create all kinds of institutional changes as a result of that long last why you created them in the first place. And then they're very hard to undo. So one of the things that ends up happening is we had both doctrinal changes that lead to a decline in jury trials, that the Supreme Court says it's okay for prosecutors to threaten people with really long sentences if they go to trial and exercise their jury trial right. People weren't sure the Supreme Court was going to say that was okay. It kind of had been done, but it had been done kind of on the down low. Once the Supreme Court comes out and says, well, that's okay, that increases, right? And so it diminishes the power of the jury, as does having more mandatory minimum sentences, which makes it easier for prosecutors to say, either plead guilty now or I'm going to charge you with this crime that has a mandatory minimum attached, and then you will, if you are convicted, you're going to get 10 years, 20 years, 30 years, life. Similarly, pretrial detention increasing means that people will plead to get out of jail, right? They just want to get out. So they'll plead and take time served. So you really see a decline in the jury as a result of these factors changing. We talked about the decline in clemency and parole, these second looks that take place. And we also really see far less court oversight, in part because of mandatory sentences that makes it difficult for judges, in part because of some changes to the bench itself that I want to talk about. And so what you see are institutional changes that are really critical to pay attention to, because if you're going to dismantle this, you need to think about these institutional dynamics and how you're going to undo them. And in addition to that, I think you also need to think about money. So some of the themes in Frank's book talk about this kind of insidious momentum, as he describes it, of mass incarceration. So we invested money in things. And when you start to invest money in things, when you hire more district attorney, ADAs, more assistant prosecutors, when you hire more law enforcement agents, now they're in place and they have to do something, right? They're there. When you build more prisons, you can fill them. And it's very hard to close them. And it's very hard to lower the number of people who work in these jobs. And so those are really important changes that create vested stake in keeping things as they are because people's livelihoods depend upon it. In addition to that, to thinking about how law enforcement budgets have ballooned, Frank's book reminds us that it has created an environment and a culture where the measure of success for folks can be these long sentences and having kind of, for prosecutors, that's a badge of showing that they've been good at their job. So we need to think kind of culturally how that gets dismantled, because if that's the measure by which people are judging themselves, then we'd have to figure out what other measures could be used instead that may be better. And again, thinking about the costs of how expensive incarceration is that we also have, because of our structure in states, that your local district attorney, when they put somebody in state prison, that doesn't cost them very much money. Because they don't have to pay for it. And so it's a free resource that, as Frank and his co-author had talked about before and talks about here, we have it's a correctional free lunch. It creates financial disincentives for reform. So in the time that I have left, I'm going to quickly go through 3 pillars of reform that I think try to dismantle this institutional dynamic that I think is critical. So I want to start with prosecutors. And here, that's a set of actors who use their discretion to increase incarceration. And so one corrective is to think about how to rein that in. And I think there's a host of things that we could be doing on that score. So one is thinking about the way in which they do use pretrial detention as a leverage point for themselves. And cash bail is often a big part of that. We can eliminate cash bail without any effects on public safety. It's just penalizing people who are poor. We could dramatically lower pretrial detention, and that has an enormous effect on prosecutors' ability to leverage pleas, mandatory minimums. So these are some policy things that are not only good policies in their own right, but they really do affect the leverage that prosecutors have. Open file discovery, second looks. But I think it's also important to focus on how you go about doing that, how you get that. And we are seeing a movement around the country to elect more progressive prosecutors. And here I will just say, and I'm happy to talk about this more in questions because I'm getting my time is running out signs, that when we're thinking about what it actually means for someone to be progressive, if your goal is actually to have a prosecutor who's focused on data and evidence and what actually works to reduce crimes, then they should be out there on the front lines advocating and lobbying for these changes. Even when it's against what might be the kind of professional interest of making their job easier, they should be guardians of public safety more broadly than and advocating for exactly some of these reforms that I'm talking about. There are other things that they could be doing as well, and I'm happy to talk about that more when we get to questions, if you have them. But one of them is also making them internalize the costs of incarceration, creating financial incentives so when they're deciding to send people to prison, it's just not completely free for them. So either financial incentives to give them rewards when they don't, or penalize them when they do. Second key reform, an area of institutional change, really does get at this idea of using the agency model, or how we think about agencies. Because really prosecutors can't go it alone here, even the most progressive ones. They're not responsible for this whole category of criminal justice policies. And we do need people who do take a coordinated approach to things. This is not a problem unique to criminal justice, right? This is a problem that is true across regulatory spaces and areas when we regulate health and safety. And so what we want is to make sure that we have people who are looking at the best evidence we have and doing the best they can with the information available to us. And so if we think about using an agency model, we can use that as a potential path forward, right? So they could study incarceration policies, things like visitation policies, policies, things like where people are confined, collateral consequences, second look, and give us kind of the best that we know on our existing knowledge. Frank talks about this in his book as well, talks about sentencing commissions as places that have done some good, particularly when they have been limited by capacity constraints, because those capacity constraints are very helpful in rationalizing. You have limited resources, so if you'd have to build additional prisons as a result of that, then maybe we shouldn't do it. Maybe we should find a way to think about, are there different policies we could pursue? And for example, Frank highlights, and many of us as well, the Minnesota Commission, the Minnesota Sentencing Commission is an administrative agency that has done a pretty good job in terms of using its ability to rationalize resources as a potential model. I agree with that. I think the experience with sentencing commissions in the states backs this up. Not all of them are great, but on net, they've actually done quite well. Sentencing commissions have gotten a bad rap because of the one that I worked for. And I totally get that because that is true, and it's important to ask why that sentencing commission was particularly bad and why the others have done better. And so when we're thinking about using sentencing commissions or using agencies, it's important to kind of take the best agencies that we've had using criminal justice policies as opposed to looking at the worst and deciding, well, then it can't work at all. So I would like to just kind of, the cautionary tale on sentencing commissions is just to say states with sentencing commissions have slowed the growth in corrections in correction spending in their states and have saved money, and they have slowed the growth in incarceration. So this is a model that can work, and we've learned some lessons from those commissions of how they can be designed. That's the key. You need to design these agencies to reflect the political environment in which they work, which means that they really do need to have these kind of capacity constraints built into their operation. And frankly, they need to look more like other administrative agencies that have to explain why they're doing what they're doing to courts so that it's not just all politics. So you actually have policymaking that's not arbitrary and capricious. I could say lots more about the agency model, but I want to be sensitive to the time and get to my third category of things, which is I want to bring the courts back into the conversation. So when we think about what sparks change in American society, certainly it could be this movement to elect progressive prosecutors. That's good. Certainly, to the extent there's a movement for criminal justice reform, I hope it's used to have some of these agencies put in place, because I think that's the kind of long-term thing we need. But the other thing that can spark change is a court decision. When our courts protect constitutional values, that's actually critically important. The Supreme Court did this. California's reforms would have never gotten underway at all if it weren't for a Supreme Court decision in Plata that held that their prisons were unconstitutionally overcrowded. So if we think about the two biggest reasons for incarceration the biggest incarceration drops, one was the U.S. sentencing commission, 30,000 people being let out of federal prison early is a big one. This one is enormous in California, and it was sparked by a court decision. So we see both the importance of an agency and we see the importance of a court. But Plata, and I cannot emphasize this enough, was an outlier Supreme Court decision. By and large, the Supreme Court has done nothing to check mass incarceration. And in fact, it has done nothing even though there are doctrinal areas where it should be doing more. So we do, in fact, have an Eighth Amendment that bans cruel and unusual punishments. But the Supreme Court has done very little outside the death penalty to police it. It has created immunity doctrines for police and prosecutors out of whole cloth that are not to be found in the text of anything. It has failed to enforce the fact that you should not be imprisoned in America because you're too poor to pay. And federal courts around the country, unfortunately, are failing to enforce that protection. So people are being incarcerated because of fines and fees that they have not paid. So when we think about, well, why might that be? Why do we have a bench that hasn't done more? I want to just emphasize the fact of who's on it. And this is something I didn't need to limit it to the bench, by the way. We have former prosecutors kind of dominating public life. They run for office, they are governors and legislators, but I do want to focus on the fact that they are our judges in disproportionate amounts. So if you look at the federal bench, It is really an enormous number of people on the federal bench have previously served as prosecutors. And as compared to people who served as criminal, either did public defense work, you can see it's a 4-to-1 ratio. And this imbalance persisted even under President Obama, who was claimed to be very interested in criminal justice reform. So before he took office, it was 43% of the judges were prosecutors and 10% had public defense experience. After his 8 years, 41% had prosecution experience and 14% had public defense experience. So the needle was moved like that much. I was recently at an event at NYU that Judge Restrepo of the Third Circuit was at on this topic, and he did some of his own counting. So he found we've had 19 Supreme Court justices with prosecution experience and 0 with public defense. Of the 163 active circuit judges in the United States, 53, so these are appellate, 53 were former prosecutors. 57 were former prosecutors, 5 were public defenders. If you look at state courts, it's similar. States with elected Supreme Court justices, 39% were former prosecutors, 8% former defenders. I know you might think, oh, maybe it's better in states that appoint their justices. In appointed jurisdictions, 53% were former prosecutors and 3% were former defenders. In addition, Cato did a study of how many judges on the federal bench. What if you didn't even limit yourself to just criminal prosecution, just government side, like they were government side, civil, for example, enforcers. And when you do that, it's a 7-to-1 ratio in favor of people who worked for the government. I think that's really important. I think it's really important to ask if it's healthy to have a bench that's this imbalanced when their role is to check the government. Their role is to help check the government against individual abuse. I think it's really important to have more people on the bench who have spent careers representing individuals against the government and protecting individual liberties. So I think it should be a critical path for reform that we think about this imbalance on both the federal and the state bench. And I think it's part of Frank's point about actors with discretion, and I think courts are a big part of that. These folks have a lot of discretion, and I think people who are interested in criminal justice reform, who are focused on prosecutors, should, in addition, really think about judges as well. And so those are my big 3 institutional pillars. I will stop there, and I think there's time for questions. Okay. Can we go over here? Okay.
Okay, I have note cards from a bunch of you. I apologize in advance if we can't get to all of your questions, but we will see what we can do and try to group some of them together. So one of the themes that comes out in the questions is this trade-off between expertise and public engagement. And the idea that in addition to having agency experts, we should also be engaging with people who actually live in the communities that are affected by both crime, but also policing. And so can you say a word about kind of in this more administrative model where the role is for kind of people in the trenches?
So the public is absolutely, I can hear me?
Acoustics are pretty good.
Okay, all right, so I'll try and be as loud as I can. So the public is critical to all this. So it's never the case, and sometimes I have been kind of a caricature of my argument is that somehow this is like ruled by experts and, pointy-headed folks telling these people what to do. That's no more true in the kind of things I'm talking about than unless you think that is true, for example, in how we regulate the air and the environment. I mean, we still vote for our representatives and they set the policy for environmental law. We just have an agency in place that actually looks at the scientific evidence and tries to achieve the goals that the public has, but by looking at information that's available so we get better policies. Occupational work settings, same thing. It's the same democracy that we've always had. It's just a question of how you get that democracy to work better by getting information in there. Because it's just not the case that the public is expert on everything. I kind of fear we are living in a time where that view, because of internet searches, may become, people might think, well, I Googled it, and I didn't come up with an outcome that suggested anything that was different. It's just not true, and it's not true that criminal law is, just all moral intuition and gut instincts. And I think there is a sense that might be true, but it's not, right? We know more about things that work and don't work and what is cost effective and what's not. And the issue is if the public cares about public safety, and I really believe they do, there's a way to get better outcomes with better institutional models put in place and to save their taxpayer dollars. So, all this is against a backdrop of still having public engagement, still having local communities decide what's best. None of that would change. The only thing that would change is that you would be able to get some of the irrational results that would be something the public wouldn't want out of there. So, I think I see them as completely compatible, unless, and I will say this caveat, there are folks who think the entire administrative state is contradictory to all this. And so I guess I will say, because it's kind of using that model for criminal justice, if one is in that camp and would like to get rid of all of our health and safety agencies, then they're probably not persuaded by this. But if you think we are actually a healthier country because of their interventions, and just so you know, the data shows that we are, the same could be true of criminal justice.
So building off of that, another theme was this idea kind of as, instead of talking about public safety, that we should maybe be talking about public wellness. So even if you take an administrative model in criminal justice, it still is going to be siloed. It's a sentencing commission or a public safety commission or a prosecutor's office that is perhaps better designed. How do you actually pull the lens back and draw kind of some of the balances between public safety and its natural, or public safety agencies and their alternatives, like public health and social services and all of the other things that are essential for more of a kind of cohesive model?
Yeah, no, it's really important. I mean, particularly, we don't actually have a central planning agency, like the government agency that balances everything. That starts to get into new territory for sure. And so it's a question of how can you get alternative models that are going to be considered. I think agencies that specialize in criminal justice are capable of doing some of that work. I think they're, I'm sorry? Okay. I think they're capable of doing some of that work. But I also think that there's a limit. They're not going to become public health agencies, but they can at least study within their world of criminal justice, or if you're just kind of within the administration of criminal law, you could be doing better with our limited resources than what we are doing, even if you don't kind of radically transform into a public health model or radically if we were really meta analyzing these things, I would say we need to invest in education and we need to invest in communities, in jobs, and in infrastructure. I mean, that's just all true, pre-K. But that's a different set of politics and a different set of institutional reforms. And I'm actually making a much more modest claim, which is within criminal justice and what we do in criminal justice, we are woefully underutilizing our resources and could make a better use of those. And I do think if we started doing that, it will free up funds that my hope is that jurisdictions would use for these other things. But they don't always. We have seen jurisdictions that have changed some of their criminal justice policies. They are saving money as a result. Their crime rates are down, but they get to choose because of the public. The public gets to choose what it wants to invest in, and it's not always in some of those longer term results. It's just it's just one of the sad truths of our democracy. We don't do a great job at long-term thinking and long-term planning. Elections come every 2-4 years. And so those folks want to have things that they can point to the next time they are up for election. And it's tough to say, I invested in this program that you're going to see 18 years from now. Wow. There's going to be a big difference. They're going to be out of office by then. So it's not a great environment for those longer term investments. But even with those limitations, the limitation of you're just in your criminal law box, and it's not a great political environment for long term. If you started doing more of this structure where agencies had to explain what they were doing, you would see really big shifts in some of these policies. And even if some of them were just getting rid of these collateral, 47,000 collateral consequences, I guarantee you if we started really studying which ones are good and which ones aren't for public safety, you're not going to have 47,000 of those. And that's going to do a lot of good, even if it's not doing the absolute best possible scenario that we could have.
With 1 minute remaining, I'm going to sneak in one last question, and it's about the role of race in this whole process. I know, but realized giving you a minute to answer that is a little unfair. The question specifically was to what extent race played a role in Obama's kind of hesitancy to be more engaged in the clemency process, but I guess I just want to ask that more broadly, is how does that kind of fit into the story that you're telling?
Yeah, so on President Obama, I think he's just a cautious person. I mean, I really do. I think he, after trying for 8 years to get more dramatic changes on some of these fronts, I just think that's his temperament. I think he's, and you know, could it be that there's a fact that he may have felt bolder if he was trying to do some of these things not as an African-American man? You know, maybe. But I also think that he's kind of cautious and moderate by nature. And believes in kind of a going slower approach. And I do think recent statements he's made about our current political environment reflect that to be true. So on the bigger question of race, though, you know, you cannot ignore that these policies everywhere you look are tainted by racial biases and assumptions, all of them. You know, from the collateral consequences to how people are treated in prison. You know, they're certainly affecting people of all races, but I do think the politics of all this, everywhere you look, sometimes coded and sometimes not so coded, racial disparities emerge when you look at these things. And it makes it, frankly, more difficult in some ways then to figure out how you're going to solve, because you're not just kind of trying to solve the politics of criminal justice, but you're trying to solve the politics of race in America, which is, you know, it's no easy task for anyone. Having said that, I will say it does help to focus people away from rhetoric and emotions and biases to information and data, you know, because then when you start to do that, and what's nice about that is so often these policies, if you just kind of look at them dispassionately, what they do end up doing, though, is disproportionately benefit the same communities who have suffered the most under the previous policies. And so when you lower sentences, when you change some of these collateral consequences, what you are seeing is, although they weren't all targeted with racial justice in mind, they have a disproportionate benefit for communities of color, because those are the same communities that suffered disproportionately from having them. So I do think there's a way, there are things we could do that's more explicit than that. And I do have some suggestions in my book, for example, about thinking about racial disparities directly. That, you know, that's something, there's racial impact statements could be used in policies to really focus people on those things. So I think it could be done more proactively, but I do think we all have to be honest in terms of the politics in America. And it's a tough hurdle.
Great. Well, please join me in thanking Professor Barco.
Thank you.
Ladies and gentle people, it's probably about time to start, but I am going for 30 seconds to speak very slowly to enable more people to enter the room before we start. My name is Mike Tannery. I am one of the lesser lights in a pretty distinguished criminal law faculty at the University of Minnesota, which is my great fortune. And I have the privilege, and maybe because of my age, the organizers weren't given a choice as to whether to give me that privilege to introduce one of our speakers today, which I'm about to do. But before I do that, I want to say just a little tiny bit, not about the person, but about the setting. So there was a time when the United States did not have the cruelest, harshest, most racially skewed punishment system in the Western world. If we go back to the 1960s, the United States locked up about the same percentage of its population as did governments in the other English-speaking countries. And the notoriously severe outliers were Finland and Switzerland, which had imprisonment rates significantly higher than America's. In the 1960s, from the early 60s until 1973, imprisonment rates were falling in the United States. It was a very different country in relation to criminal justice policy. Now, our speaker, Al Blumstein, about whose career you can read in the brochure. I'm not going to repeat it. He's done many important things. Was a boy in the 1960s when the imprisonment rate was falling and when the United States was not the notorious outlier in criminal justice policy. Even though he was a boy, he was, as an enfant terrible, the head of science and technology for the most important exhaustive look that was ever taken of the American criminal justice system, something called the President's Commission on Crime and Law Enforcement, that issued a famous report in 1967. So he was a youngster then, even younger than he is now, and was involved in an elaborate policy process trying to devise ways to improve what was then seen as a deeply troubled criminal justice system. So Al's career began at a time when this was a normal country, and the policy issues he dealt with for the first 10 years or 15 years were those of a normal country. Since then, of course, things changed radically. I won't repeat because I'm sure you've been told about rises in incarceration rates and leading the world and so on. But Al has lived through all of that, much of it in hugely important and influential roles. And he's going today, I think, to be willing to come to the front here. Why don't you come to the front here, Al? And offer some reflections on where we are now. Probably not so much on how we got here, but if that's what he wants to talk about, that's great. And probably more importantly, on how we might hope someday to return to the world mainstream. So I introduce Alfred Blumstein.
This is my clicker, I guess. I want to be talking about the problems of mass incarceration. And I'm going to be drawing on work I've done with Alan Beck, who's at the Bureau of Justice Statistics of the U.S. Justice Department, and with Kiminori Nakamura, who's at the University of Maryland. And I'll try to refer to them. For the analytic work they've done, don't blame either of them for any of the policy discussions that I'm going to raise. First, I want to start out with looking at a century of U.S. incarceration. This is the graph that I'm sure many of you have seen that has a impressively flat incarceration rate from 1925 to not quite 100 years, but for 50 years. And then we'll look at some of the pieces of that graph. What I want to do is start out with that century of incarceration that was extensively addressed in 2014 by a panel of the National Academy of Sciences. It was concerned with the causes and consequences, not with any of the solutions of it. And you've heard this morning some excellent presentation about solutions and how to deal with it. But it was recognized as a problem, but they didn't address solutions, and others have proposed their own solutions. And one of the most impressive set solutions have been those proposed by Michael Tannery. And there's just a rich volume of material that he has put together with himself and others in works that he has edited. And just there's a whole encyclopedic material that Mike has been very important in putting together. And Frank's book is now an important addition with his own analysis. The U.S. current rate, as has been pointed out, the peak was 506 per 100,000, and I'm going to refer to just the rate without the denominator of per 100,000 in much of what I'm going to be talking about. which, as Mike just pointed out, is very much the highest in the world. And the industrialized world, most of it is between 75 and 150. And the US used to be at about 100 roughly. And I'm going to look at that in some detail. And I want to look at the first half of that century, from 1920 to 1970. And it's a fascinating picture. It's phenomenally stable. And if you look at that blue line, that's the trend line that runs horizontally through that graph. That suggests that it was really a very stable rate that had its ups and downs. The ups occurred during the Depression, when there may have been more crime and more incarceration. Down during World War II, when the nation had much better use for the young men who would otherwise have been languishing in prisons. But it was an impressively flat rate and one of the early papers that I did, let me note that Mike pointed out, does this have a light? Nope, it has an on-off switch. No light. But if you look at the end of the curve, it has a light?
I believe so. I think it's that star button. There you go.
There it is. You see it just starting up, and so that was the start of that big upsurge that you're going to see later on. Let's just say something about the first half, an impressively stable incarceration rate. An important feature was that incarceration rate was under the control of the functionaries within the criminal justice system. So that when prisons were full, then the parole boards would find a means of letting people out a bit earlier so that you'd make space for the people yet to come in. When prisons were underoccupied, then you could pay attention to the crimes that were secondary of concern, things like pornography and a whole variety of secondary crimes of secondary concern, so that the system was stable and maintained that reasonably flat incarceration rate. That rate was 110 per 100,000, went up during the Depression, went down during World War II, and it impelled Jacqueline Cohen and me to write a paper entitled A Theory of the Stability of Punishment, looking at the ability of the system to maintain its control. And the paper was published in 1973, just as the basic theory was contradicted and shown to be way off base, because other things could happen that would make it do differently. So then we moved into this dramatic rise of the incarceration rate. Just about all of it occurred in the 80s and 90s. It started up in the 70s, and as a percentage rise, it was fairly large percent, but the base was 110. But the percentage of the growth was predominantly in the 80s and the 90s. We looked at Alan Beck and I looked at the factors contributing to a rise in incarceration. Could it be an increase in reported crime? Could it be a growth in the arrests per crime? Police were getting a lot better. There was a lot more sophistication, a lot more technology used by police in finding offenders. Or it could be an increase in prison commitments per arrest. Or it could be an increase in time served. All of those can contribute to that phenomenal rise. it was neither the arrest changes were significant, nor the arrest. It was neither crime growth nor arrests per crime that were growing. It was what was going on in the judicial system, the prosecutors, the judges, the parole boards that were contributing to that growth, predominantly commitments and time served. Initially, it was predominantly commitments. About 3/4 were because more people who were arrested being sent to prison, and later on, transition around 93 occurred with a switch to time served being about 3/4. So it was essentially the judicial system that was making that change. And contributing to that was the 1974 crime bill with truth in sentencing. And truth in sentencing, what was the argument in truth in sentencing was Congress saw crime going up and up and up. In 1974, they didn't realize that crime had peaked in 93 because the Uniform Crime Reports for 1973 hadn't come out, for 1993, hadn't come out until 1995. So that they were unaware that it has started down, and started down in very interesting and important ways. But they didn't know that. They were reacting to the growth in crime. And so the Truth in Sentencing bill said that states who made people who were convicted of violent crimes serve at least 85% of their sentence could get federal money to build more prisons. So the federal government was providing the incentive to provide longer time served. And I'll say more about the growth in incarceration for drugs. There are the court commitments, and that sort of orangey line is the number of commitments for drugs. But drugs weren't serving very long, and there was a lot of arrests for drugs. That was the start of the drug arrest epidemic. And so you get a sense that something, and that black line is the one for assault that was going up appreciably. And the others were not dramatically changing, but the important one was what was going on, drugs and assault. And so the theme here was violent crime. This is total court commitments. But when we look at court commitments per arrest, that sort of orangey line for drugs is down there at the bottom. Well, it's down there at the bottom. And the one that's going up dramatically is the one for murder, where interestingly, there were only 40% of the commitments for murder in 1980 were being sent to prison, whereas it was back in the 90s. And that was a major growth. But there was general growth. And the other one that saw major growth was that sort of deep red one for sexual assault that was going up rather sharply. And of course, assault, again, the black line was going up rather sharply. So that what we saw the rate of commitments going up, and then the time served was really going up dramatically again for murder, that red line, going up particularly strongly for sexual assault and to some degree robbery. So it was very much a focus on the violent crimes without the corresponding attention to the other kinds of crime. Let me say some more about that crime bill. They got the federal money to build more prisons. Violent crime still seemed to be increasing, and the Uniform Crime Reports wasn't very helpful in sorting it out. There's the incarceration rate from 1920 to 2017 that crept in again here. The solutions and their effects, and you will hear a lot more about it. You heard a lot about it earlier this morning, and you'll hear a lot more about it during the day. Mandatory incarceration to replace probation. Specified mandatory minimums. 2-year mandatory minimums didn't do much good, so they upped it to 5-year mandatory minimums, and then up and up. It didn't. Now, it was started by mothers, parents who were very concerned about their kids, and I'll say more about that, but recognize it didn't have much effect on drug markets, even though we were getting really heavy in the mandatory minimums on drugs, because locking up a drug seller didn't have much incapacitation effect or deterrent effect, because locking them up generated a recruitment of replacements for the people who are locked away. When you lock up a rapist, you tend to take his rapes off the street. When you lock up a drug seller, you encourage the market to recruit a replacement. And one of the problems was that the replacements tended to be young people rather than more mature people. If you're in the drug markets, particularly in the crack markets, which were street markets, you better carry a gun, because you can be vulnerable to robbers who are going to take your drugs or take your money. And so that there was much more appearance of guns in the streets, particularly associated with the crack markets. And that was why there was a major growth in that period of African Americans in prison, where incarceration rate of blacks was about 8-1 at the time. It's now down to about 5-1 as those crack offenders were released. So recognize that it didn't have much effect on the drugs, but it worked for the political system. The public was very concerned about drug markets. The politicians didn't know what to do about it, but they knew they had control of sentencing. And so we saw that major growth in sentencing, and the public was pleased and appreciative, because the public is insensitive to some of the subtleties, and the public generally views anything that is locking people up as going to work at reducing the crime we care about. And so it worked politically, but not very effectively in terms of reducing the crime problem. So it worked so well that the political system said, hey, we can do it with other crimes too, and we'll get even more enthusiastic response. So it was replicated to other crimes of public concern, and especially for violent crimes and sex crimes, which were the crimes that the public was particularly concerned about. So there was another feature. These were parole violators who were being sent back to prison. And again, this sort of grayish line up on top is the drug parole violators. When they got out on parole, they obviously went back to the drugs that were an important part of their lives. And so we saw that growth in parole violation. And so that represented an important part of the growth of incarceration, because they got sent back to prison. The consequences of that political response were that we saw very vigorous enforcement of the drug laws starting in the early 80s, street drug sellers off to prison, and especially the strong impact for crack. And the juvenile drug arrests didn't go up until 1985. The enforcement started in the early 80s, but the juveniles took over in 85, and they were the replacements. Street sellers had to carry guns. They had to protect their drugs and their money. Homicides by young people increased markedly, up to a rate of about 10 per 100,000, peaked in about 1993. And here's the crime picture. And if you can look at that peak in if you can see that peak in 1993, which is just before that was about, this is murder and robbery. Robbery is divided by 25 so that it's on the same scale as murder. And you see that peak of both in about 1993 and about a 45% drop between 93 and 2000. So we saw crime coming way down, having nothing to do with the growth in incarceration, but having to do with very much a recognition of some of the physical consequences of the crack markets and a reduction in the demand for crack, and the economy was strong. It started down at about 93. Serious personal effects of the crack. Fewer sellers were needed. The economy is strong, so jobs were available, and especially for the African American victims as well as offenders, particularly young people whose violence went up during that period and whose victims correspondingly went up during that period. Joel Wallman and I did a book on the crime drop in America. That 45% drop was impressive, from roughly 10 per 100,000 murder down to about 5, and it's been pretty stable, generally coming down slowly since then. And Frank Zimring, of course, had a great American crime decline book that also addressed that decline, which was a striking event in the criminal justice system. Again, we talked about the 1994 bill, and about the not availability of the UCR crime reports to know that the crimes were starting to come down. Okay, let's now look at the last decade of the 20th century. That's from 2000 to 2017, not 2007, 2017. It's obviously very flat, and let me just show you this is that graph from 2000 to 2017, impressively flat. And so one of the first responses, we're seeing a new stable rate from 2000. And again, there's a trend line that itself is impressively flat, but because the curve is very flat. So let's go back and look at some of the factors in it. Slow rise and a slow decline. It turns out that it's not quite flat. It really is a slow rise from 2000 to 2007 and 8, which was the peak, and the concern that could be another new normal or a new stability that we're entering. And that's one of the first reactions to that flatness. But it's really steadily up until 2007 and 8, and then steadily down. So even though it's quite flat, it really had very much of a clear up period and a clear down period, but very small rates. The peak national rate was about 506 compared to our 110. And there is, so this is the slow beginning of a reduction. It could be the end of the rise and the beginning of the decline. But it's the peak of 2008 did decline to 440 by 2017, but the rate of decline was impressively slow, was only about 1.5% per year. Consider the possibility that the decline rate would be doubled to 3% per year. If that were the case, that would take 23 years to fall to Mike Tannery's favorite effect of halving the incarceration rate. It would take 23 years, even at 3% per year, to fall to half of that peak, which would be a rate of 220. That would still be double America's stable rate for 50 years, and still well above the rate of the other industrial countries. So clearly we need a more aggressive effort to reduce the incarceration rate. Most states' incarceration rates are declining. 38 states reduced since their recent high, with highs ranging from 1999 to 2016. And 20 of those states had double-digit reductions. So we did see some important reductions. And New York State was down 32% since 1999. New York really committed to a significant decline. They were part of the double down. California was down 25%, but California was not quite natural in that the Supreme Court decision that required a reduction was a major factor in contributing to California's decline, and that made California go down, and the others. So 11 states were increasing steadily from 2012 to 2017. So there was a contrast, but 11 versus 38, if you did the arithmetic, one was zero change, and so not much going on. The national decline was only 7.3% since 2009. And so in the process, Frank Zimring is making some very positive comments and appropriate about what California did in bringing its rate down, and it was forced by the Supreme Court decision, and introduced a variety of very reasonable approaches: jail or community or local prison, jail or community service rather than prison. Raise the misdemeanor felony threshold so that for less serious crimes that hadn't been changed, that was a way to make sure that the bad guys went to jail rather than to prison. Keep parole violators locally in the jail rather than sending them back to prison. Increase the use of probation. Increase state funding to counties to accommodate, and those consequences represent a slow but steady reduction of the prison population. The major increase in most jail populations, and jails were not an issue in the Supreme Court decision, so the state was free to reduce the prison population that they had to do, but they didn't have to take account of the pain they were causing to the jail populations. And so there was a significant increase in jail suicides as one of the consequences of the increase in the jail population. So realignment was certainly a reasonable approach. California benefited from courts forcing the reduction. Jail is an important aspect of reducing state prison populations. And Frank Zimring report seems to support realignment generally, but highlights the value of keeping offenders close to home and recognize the need to improve the quality of the jails, and there's much that could be done for that. And he's got a chapter that really focuses on ways to improve the jails, enhance the services and resources available in the jail, and other approaches that could be used. Reconsider all the changes enacted, all the many changes in legislation and sentencing policy that were enacted. Pursue drug use problem as a public health issue rather than as a criminal justice issue. Bail reform via risk assessment that's going on widely around the country. Greater focus on rehabilitation, and many more. And one other issue I'd like to talk about, Frank has highlighted the collateral consequences, and the bold-faced items represent concern for recidivism and public safety, and usually those consequences should recognize that recidivism declines if there's no further involvement with the criminal justice system, and those consequences usually run forever. And it does decline with time clear. Let me move forward to, this is a graph of the work I did with Kiminori Nakamura on the recidivism of years since release and rearrest as a result of having been arrested. We also looked at prison releasees, and clearly they start out with a higher recidivism rate and come down, and what you see at about between 10 and 15 years, they're clearly worse at the beginning because they're the ones who went to prison and they had prior records. The arrestees were first-time arrestees, but they do converge to a comparable risk level. And so there ought to be some attention. There ought to be some redemption time, and that redemption time is when the collateral consequences should be lifted. And that will vary with age, crime type, concern about the next crime, and that's what you get to see here. And so some reasonable next steps. Prison population reduction is widely recognized. There warrants a coordinated effort funding by the federal government. And Zimring's suggestions and other suggestions to the states, to the state criminal justice planning agencies, Department of Corrections, or the sentencing commissions, who are the organizations, again, that can do the evaluation of what works politically and what works functionally within their states. And they should consider the various approaches and include evaluation information on effects on prison population and effects on crime. And there should be a national agency that would compile all of this information and provide guidance to the states that what works in their political environment and what works in their functional environment would be very helpful in being able to combine the results. That would be it. Okay.
Fantastic. All right. So now we do some questions. If you'd like to sit down, you can.
I'll stand.
Okay, all right. So we're both going to stand. The drill is we've collected some questions in writing that I will ask you.
Great.
And then we'll have a bit of time. And if people want to ask questions from the floor, that's okay too. So I will give you the most challenging question first. Activists believe that criminal justice policy changes of the 1970s, 80s, and 90s were driven by negative political reactions to the civil rights movement and by, for lack of a better term, racial bias, or racial insensitivity on the part of policymakers. You don't discuss that. How come, is the question.
The growth of, there's a fascinating book by Michelle Alexander that blames the growth of concern about drugs on the Southern strategy of the Republican Party, which was essentially driven by racism. There's no question that there was some effect in the drug market, but there are two effects that were going on. One was this parental concern that I raised, some concern about drug markets, and a naivete bordering on stupidity about the effectiveness of being very punitive on drugs. That contributed to a real desire to reduce drug abuse, and a naivete and not realizing that they weren't doing very much of good through incarceration, as well as some Southern strategy as part of the effort to see to it that, as Michelle Alexander talks about it, as the new Jim Crow, that it was an attempt to lock up blacks. It's tough to sort that one out. There was undoubtedly some of those in there, but I think the major one was responding to the public concern about the harms being caused by drugs. The recent opioid crisis was a good example of being much more intelligent about dealing with the drug problem, by recognizing it as a public health issue, by dealing with rehabilitation and treatment in a variety of creative ways. And the counter-explanation there is, yeah, but most of those opioid crises were whites. So there could well have been a new Jim Crow, but I think it was accompanied, and no one's done a very good job of sorting it out. Michelle Alexander has picked on one aspect. I think both are in there to some degree, and I don't have the basis for adequately sorting it out. And so recognize that it's in there in both ways. And the comment I made earlier about the black to white incarceration rate per capita was about 8-to-1 during the incarceration period. The follow-up period has been one of the growing departure from incarceration of black offenders caught up in the drug problem, down to a current level of about 5-to-1.
Okay, question 2. How do gun laws, or how does the lack of gun laws, affect incarceration rates?
The lack of gun laws is clearly a major consideration of violence and the consequences of violence. And what we've seen is the growth of the power of guns, and the lack of gun laws restricting the power of guns. That the high velocity and high cartridge discharge rate of guns have been a major factor in the growth of very serious violence. There's no, and part of my counterexample would be New York City. New York City had undoubtedly excessively aggressive search and frisk laws. The homicide rate in New York City, contrast, the homicide rate in the U.S. was hovering around 10 per 100,000. After the crime drop, it was hovering around 5 per 100,000 for the nation as a whole. New York City is hovering around 3 per 100,000. The effect of the high rate of stop and frisk, which did have, again, racial effects because they were searching in the neighborhoods where there was high violence, high homicide and high shootings, and those were the African American neighborhoods. So there was an excessive searching and inappropriate searching, but in terms of effects, I think that the stop and frisk did have a major effect and has a continuing effect of deterring the carrying of guns, and the carrying of guns in the street were an important factor in the high rate, in the major reduction of homicide in New York City. I'm not arguing that we ought to have a lot more in the way of stop and frisk, but that things that would restrict the availability of homicidal guns would be a very important part of that response.
Okay, I have one last recorded question, and then we'll open it up. So this question says that Minnesota prisons are full of probation violators. What role do you see for probation reform in addressing mass incarceration?
As you saw in one of those graphs, a large fraction of parole violators are people who were arrested on drug charges. There's the possibility that was initiated by Project Hope in Hawaii for having people who are out on parole tested periodically for their drug abuse. To the extent that they are using drugs, then they become major candidates for treatment for their drug abuse, rather than sent back to prison, from which they will come out and become drug abusers again and doing drug crimes or other crimes to get money for drugs. So obviously, sending them back to prison is not a terribly effective way to deal with drug offenders. It makes so much more sense to try to do something in the community while they're there, and they were a large part of the parole violator. So that parole violation, particularly for the technical violations, rather than for new crimes, ought to be done in a more rational, sensitive way to see what are the causes contributing to that growth of incarceration, and do other things locally. And certainly jail is, if you've got to lock them away, jail makes a lot more sense for a relatively short time. If they've done a new crime, deal with a new crime, but don't blindly send them all back to prison, which has been the typical parole violation treatment. It's an obvious candidate for more intelligent processing.
Okay, now do we have any more questions from the audience? Yes, sir.
Michelle Alexander argues in Jim Crow that beefing up the drug laws was used in selective prosecution of minorities and resulted in higher incarceration rates and sentencing. Wouldn't strengthening the gun laws be a candidate for the same effect by law enforcement to selectively enforce the gun laws against minorities and gangs because of the increased sentencing and incarceration potential of violations?
It's easier to not continue carrying your guns if you see that guns are not available, if you see that you're going to be in trouble carrying the guns, and if you see that the environment has fewer in the way of guns out in the street, that you'll feel safer not carrying guns, so that guns are not necessarily anywhere as widespread as drugs. And the problem with drugs is that it becomes addictive, and the addiction is nowhere as intense as it is with guns, except many people carrying guns are carrying it for their own personal safety. And if your personal safety is made more secure by control of the availability of guns, that'll be very different than the issue of drugs. So that gun laws certainly require strengthening, controlling the high high firepower, multiple rounds, large magazines that increase the probability of killing rather than injuring. There ought to be much more in the way of gun law, much more in the way of gun availability reduction, and that can be far more effective than the incarceration for drugs, which typically got targeted in the neighborhoods, and that's why crack markets, which were street markets and availability to be detected by police, as opposed to indoor markets of cocaine or door-to-door delivery of other drugs that were available and less visible to the police in terms of their search, so that the gun control, were it not for the pressure on the political pressure, ignoring the gun law, ignoring guns, needs to be modified. And I have a hope that within the next few years, we might see some of that reaction, partly as a result of the crazy mass shootings that we see, and partly because of the corruption we see flowing from the NRA and the political colleagues.
Okay, so we have a few more minutes. Yes, sir.
Grew up in Los Angeles. Spent a lot of years in the cocaine deal. I'd like to know, it seems like everybody's aware of the effects of having been in prison and the inability to assimilate psychologically, job-wise, employment. Why isn't there legislation? Why isn't it more, this is like the core, it seems like why people go back, you get to why they go back. Why isn't that like central?
Part of that was in my discussion associated with the collateral consequences. There are collateral consequences, most of which are concerned with safety. Most are concerned with the fact that somebody who did something bad has a greater risk of doing something bad in the future. And so many of those collateral consequences are imposed forever and doesn't take account of the fact that people who have served time, almost all of them, end up being of low safety risk after some period of time. In many cases, that period of time is appreciably less than 20 years, so that any continuing those collateral consequences of 20 years or more should have a heavy burden, and that should be imposed. And then one can do analysis when the people who are have been a risk are no longer a risk, are no longer a greater risk than the general population. Those are when the redemption time ought to kick in, and the collateral consequences ought to be relieved. But there is a perception that they are a higher risk, and essentially shortly after they did something wrong, shortly after they were released from prison, or shortly after they were put on probation and released, they do represent a higher risk, and the public is concerned with public safety. And that was the reason for the imposition of those collateral consequences. That's understandable, but holding them to that for a long time, or inappropriately, as the previous speaker highlighted, there are people like the rape laws that relate to boyfriend-girlfriend in teenage years are crazy things to hold against them forever. So that there ought to be more sensitive attention to the opportunity for redemption in that reasonable period of time when the risk is adequately reduced.
We have time for one more question. Is there one more question? Okay, actually, I made a misrepresentation. The nice young man here, who's keeping track, put up a card that said, but I thought I'd allow another question anyway. So I apologize for disregarding your guidance. I thank Al Blumstein for bringing your enormous knowledge and breadth of perspective and sharing it with us. And I think you are allowed to take another break.
Thank you, Michael.
Great, wonderful.
Good morning again. My name is Mitch Samoff. I'm the director of the litigation program here at the law school and an associate clinical professor. As a former federal prosecutor and criminal defense attorney, I am looking forward to the discussion we're about to have with Professors Pfaff and Weisberg. This is an exciting, totally virtual experience we're about to have as both of our speakers are coming to us via video conference. First, we will hear from John Pfaff, professor of law at Fordham University and visiting professor at Columbia Law School, on the topic of administrative failures and moral failures, looking at the role of prosecutors in the context of Professor Zimring's work. Professor Pfaff teaches criminal law, sentencing law, and law and economics. Before coming to Fordham, he was the John M. Olin Fellow at Northwestern University Law School. His research focuses primarily on empirical matters related to criminal justice, especially criminal sentencing. And you can read about the rest of his background in your course materials. After we hear from Professor Pfaff, we're going to hear from Robert Weisberg, the Edwin H. Huddleston Jr. Professor of Law at Stanford and co-faculty director of the Stanford Criminal Justice Center. He's going to talk about the blend of tragic skepticism and reformist optimism that's present in Professor Zimring's work. Professor Weisberg teaches and writes on criminal law and criminal procedure. He founded and now is co-faculty director of the Stanford Criminal Justice Center, a policy research program that devotes much of its work to sentencing and corrections reform. So without further ado, we're going to turn it over to Professor Pfaff. I think the format we'll follow here is to allow our presenters to deliver their prepared remarks, and then we'll have a question and answer session that would allow questions to both of our presenters. Professor Pfaff, can you hear me?
Yes, can you guys hear me?
Yes, you sound great.
Excellent. Well, thank you so much for having me this way. I really appreciate making this work. I guess the only drawback is that since I'm in Brooklyn, I do this short straw and I get to take the vomiting 6-year-old to the pediatrician as soon as this panel is over. So I have no excuse this time. And also I want to apologize because there's some technical glitches. So Sarah is going to be my slide advancer. I feel like we're back sort of in the 1980s with a slideshow that makes beep when you have to advance the slide. So hopefully this will work well. So I want to talk a bit about sort of basically start from a quote from Frank's book that I sort of want to focus my talk on. So next slide. Next slide. Can we get to the next one?
Sorry, one moment.
Thank you. 1 second. There we go. So the quote Frank had here says, he focused on 2 ideas about how we can go about approaching criminal justice reform. He says, no, changing the hearts and minds of prosecutors one at a time can be what's called a bottom-up reform strategy. Then he says, but a bottom-up strategy, change in attitudes are probably both unnecessary and inefficient. It is much easier to alter power relations and incentives in criminal case dispositions than to change hearts and minds. And this is best achieved by changes in legislation and administration. And I want to talk about, I think this is sort of at the heart of his policy proposal for this book. And it's one that I think has some serious concerns about what it means about what criminal justice reform should look like. So first, the change he wants to make, and is one I strongly support changing, is to confront what's called the prosecutorial moral hazard problem, which is this fairly simple idea that prosecutors are county officials. They're paid for out of county budgets. They care about sort of the county financial scenario. Yet when they send someone to prison, the state, like the actual, not in some political science abstract sense, but the state is in the thing we have 50 of, the state government pays for prisons, right? So in effect, prison is free. The DA gets to send someone to prison. He looks tough on crime, but someone else has to pay for it. And in fact, being less severe, sending someone to jail or putting them on probation, that does come out of the county budget. So being less harsh is actually more expensive to the DA than being more aggressive. And Frank rightly says we should try to correct this very striking negative externality. But I think he's drawing a false dichotomy between hearts and minds on the one hand and policy on the other, and understating what we can do with prosecutors and overstating how likely this reform is to happen. So if you go on to the next slide, if nothing else, the most obvious, and hit it again, that shouldn't have, most obvious point is that this prosecutorial moral hazard problem he describes, it existed in 1920, it existed in 1980, it existed in 2000, and it exists today. So it's not a necessary condition for prison growth, because we've had flat, stable, boring prison growth when this problem existed. We've had skyrocketing prison growth when this problem existed, and we've had prison declines when this problem existed. And so it certainly doesn't help, but there's clearly something else going on here. So I sort of want to focus on sort of three concerns that I have about Frank's approach. So next slide. So he did 3 times. There are 3. I had it animated because I thought I could control it, which makes this a little tricky. So there are 3 concerns that I have. The first concern, hit it again.
Sorry, one moment again.
It should, you have to hit it a couple more, 3 more times. There we go. The first concern I have is that he's overly optimistic about how likely we are to fix this moral hazard problem. Only one state has done it, California. They did it very grudgingly. No other state has followed this, and I think there's important reasons why no other state has done this yet. I think he's also overly optimistic that counties, if this law gets passed, that local governments won't either subvert or undermine this policy one way or the other. Counties love to spend money on punishment. And it's not clear to me that they won't sort of undermine the goal of this. And in fact, there's evidence from California's effort to fix this that suggests that they will do exactly this. And finally, I think he's almost strikingly dismissive of what the progressive prosecutorial movement is trying to do, what is capable of doing, and sort of the success that rests in it. And they're very much interrelated, because he is saying that mass incarceration is sort of a policy failure. And to me, it's actually much more of a political failure, and that you can fix all the policies you want, but if you don't change the underlying political ideology, it's not going to go away. You can't escape the hearts and minds problem, and policy can't fix that. And if the hearts and minds remain unchanged, they will undermine any policy fix you want to do. So next slide. If nothing else, and hit it again, if nothing else, one of the biggest challenges we face with this moral hazard problem is that states don't really spend that much on prisons, right? If you look at this share of state spending from 1952 to 2012, it peaks at around 3% of total state spending, right? State governments don't feel a really big effort to cut back on spending, because they're really not spending that much in the first place. So you have to really ask, why are they going to invest political capital in changing a problem that's not really there? In fact, if you go on to the next slide, you'll see the fact that if you look during the reform era, and hit it one more time, that something really striking stands out, right? Is that we talk a lot since 2010 about how we need to cut back on prison spending, because that's what's brought sort of the conservative part of right on crime into this. We'll save money. And yet from 2010 to 2015, we're spending more. We're spending more on prisons today than we did before the crunch, and we barely spent any less during the crunch. And yes, prison spending as a share of state spending has gone down, but it's dropped from like 3.6% to like 2.8%. Right? It's not a big decline. And if anything, we seem to want to spend more, which suggests there's not going to be a strong incentive for state legislators to pass this kind of reform that Frank wants us to pass. And there's actually really good reasons why. So, for example, go on to the next slide. In New York State, hit it one more time. In New York State, New York City pays 40% of all state taxes. New York City, Long Island, and Westchester pay 2/3 of all state taxes. Yet we spend over $1 billion a year on prisons. Look where all those prisons are, right? None of them is in downstate New York. They're all scattered across rural New York State. So it's not so much that the state is spending $1 billion on prisons, right? The state is transferring $1 billion in tax revenue from the high crime, high income, low prison parts of New York State, and they're transferring it to all the poor white parts of New York State, right? That's not an expenditure, that's revenue, right? Because realize we spend $50 billion a year on prison, but 2/3 of that $50 billion nationwide is wages, right? Prison is a massive rural jobs program, right? And so the idea that a state legislator where suburban and rural voters have an outsized voice to start with, that they want to cut off a moral hazard because it's bad, gets the political story backwards, because they actually want the spending, because it's not spending to them, it's revenue. It's what's keeping all these marginalized rural towns alive. Being a correctional officer is a horrific job. Suicide rates are on the order of active combat military, but oftentimes it's the only good paying job in the area, right? And so we shouldn't really view this as a cost. I don't know why legislature would defeat this massive transfer program. If you go on to another, in fact, to see why spending has gone up over the budget crisis, right? It's interesting. The number of correctional officers has actually fallen as prison populations have fallen since 2010. And the prisoner to correctional officer ratio has stayed about constant since 2010. But real spending on wages has gone up by almost 20%, right? We are spending more and more and more on prison guards every single year. And that's gonna make it very, very unwilling for state legislators to cut back on this sort of rural welfare program. In the North, oftentimes it's a white rural welfare program. In the South, the story gets even more complicated, where prisons tend to be located in towns that are disproportionately minority. And so the financial implications of decarceration are incredibly complicated. But it's not just financial revenue, there's also political revenue. So going to the next slide, one of the great sort of political implications we have here is what's called the prison gerrymander. In all but 6 states, prisoners count as living in the prisons. And in all but 2 of those states, they cannot vote, right? So the first picture you see there, that's Stillwater Prison in Minnesota, Minnesota. The next one is Muddy River Prison in Illinois. And if you click the next slide, click it one more time, that's Illinois River Prison in Illinois as well. And you know, blue dots are white people, green dots are black people. You can identify prisons basically from space, right? You can see these giant blocks of green, and those blocks of green are where black people are incarcerated in prisons where they're not allowed to vote. And state legislators all across the country depend upon those bodies, effectively a 5/5 compromise. They need those bodies in their prisons to keep their districts safe, to keep their populations above the cutoff line to be redistricted, right? So why would a legislator vote to transfer prisoners out of their prisons if it means that the next census they're going to lose their seat, right? And so again, these prisons, while they're a cost to the state and a huge social cost to the communities from which the prisoners come, they are not actually costs to the legislators who have the prisons in their districts. And so I remain unconvinced that legislators are actually going to want to pass this law. And tellingly, the only state to do is California, and they only did it with an overcrowding situation that was beyond anything any other state in this country knew. And it took the Ninth Circuit and the Supreme Court and 20 years of litigation to get them to do this. Right? This is not something California entered into voluntarily, and they are perhaps the most promising case for this kind of internalization policy to be adopted. Right. So that's my first concern with Frank's idea, is that while I agree that we should try to deal with this prisoner internalization problem, I'm not convinced states are going to pass it. But let's assume states pass it. The next problem we have is the fact that counties might just spend more money, right? So click it 2 more times just to highlight what I want to highlight here. Right. So this is from an article about how small counties in America are getting harsher and harsher and harsher, even as the country as a whole decarcerates. Right. So you got this small county, Indiana, that's sending more and more people to prison and jail. And despite having a fairly small budget, they still managed to find $11.5 million to double the local jail and 11 more to build up the courthouse. And then the incredibly aggressive DA goes on to say, with no irony, that he wished the county could find money for drug treatment. Well, I see $22.5 million staring back at me on this quote alone, right? They have the money. They just choose to spend it on punishment. That's what we do, right? Even in an incredibly progressive, nominally progressive place like New York City, when we got $1 billion to fight the opioid crisis in New York City, fully half of it went to the NYPD to prosecute death from drug dealing cases. Right? This is how we respond to things. And so if the goal of internalization is incarcerate fewer people, the concern I have is we're just going to lock them up locally and cut other services. So go on to the next slide. Here's a stunning quote from the 1980s about death penalty costs. And this DA in California says, if we didn't have to pay $500,000 a pop for Sacramento's murders, I'd have an investigator and a sheriff would have a couple extra deputies, and we could do some good for Sierra County law enforcement. But now the sewage system in the cars is failing, a bridge collapsed, there's no county library, no county park, and we have a volunteer fire and volunteer search and rescue. And the auditor says that these death penalty expenses keep piling up like some natural disaster they just can't avoid, right? This isn't a choice that they're making. This is just some sort of inevitable inflow of massive criminal expenditures the county's going to go bankrupt and lay off 10% of its police force. This is how we think about things, right? The DA doesn't say, I'm choosing to destroy our sewers and libraries and parks so it can go after the occasional capital case here and there that's coming out of Sacramento. It's just this inevitable, inescapable need to spend on criminal justice, right? So if the idea behind this sort of this cost internalization is if we make the counties pay, we'll lock fewer people up. Maybe if we make the counties pay, we'll just have fewer libraries and more people in county jails. And that's troubling. And in fact, California's own experience with adopting this very policy in 2011 is a cautionary tale here, right? Hit that next slide. Since 2010, California has seen a decline of about 30,000 people from its prisons due to this program they adopted called realignment that Frank argues other states should adopt to cause prison population to shrink, right? It's told the counties that you have to pay for a large number of prisoners, and prison population dropped by about 30,000 in a single year. During that same year, jail populations, county jail populations went up by 10,000. Fully 1/3 of California's success was at the state level was undone by increased punitiveness at the local level, right? So the very state that Frank lives in warns us that when we tell counties, you must pay more, you have to bear the cost, they might just choose to take the cost and cut other things. Now, there's a wrinkle with California, but it's a wrinkle that suggests the other way in which you have to be concerned. So when California adopted this realignment policy in 2011, when it told the counties for a large number of parole violations and prisoners, you have to detain them on your budget, the county said, we can't afford this. You have to help us. And the state found at first millions, and now over $1 billion in aid, right? Next slide. What eventually happened? Well, about a year later, one more time, California passed Prop 30. And what Prop 30 did, go back. What Prop 30 did, among other things, was it constitutionalized these subsidies from the state to the counties, in part to help build out these jails. As it stands now, the California DOC budget as a whole, the budget of the CDCR, is about $12 billion. This grant program, if I'm reading the numbers correctly, and following realignment is a tricky thing to do, but my understanding is these grants come to about $1.3 billion. It's a massive grant program, right? So the state tells the counties, you have to pay for this, and the counties say, why don't you pay us back? And the state did. Right. And the state did, my guess is, in part because we didn't change hearts and minds. California didn't want to decarcerate. They were told by the Ninth Circuit and the Supreme Court that they had to, and lacking that heart and mind shift, they're kind of okay helping the counties still continue to build out cages. Right. And so just because you passed a law doesn't mean that counties won't cut other spending to still be harsh, or won't successfully lobby the state to undo the very thing it just did if the state legislators' hearts and minds aren't in it. Right. And so there's two very big reasons to be concerned about Frank's proposal. The last thing I want to turn to, and this is the next slide, one more click, is his take on prosecutors. So first, he misrepresents, I think, in a fairly striking way, the way prosecutors operate. Right. He says in an adversarial system of justice, the public prosecutor is supposed to emphasize the guilt of those they rightfully accuse of crime and the importance of severe punishment in the achievement of retributive and utilitarian objectives. So prosecutors are just inherently harsh. He then actually goes on even more to analogize prosecutors to coyotes. One analogy that emphasizes the relationship between the expected behavior and moral fault concerns the predatory behavior of coyotes when sheep ranchers leave their herds unprotected by security fences. The farmers want to argue that the coyotes are at fault. Since they had not attacked the herd, none of the flock would have perished. But the moral fault in this account is more complicated than that issue of cause and fact. The coyotes in my story were behaving just like coyotes always behave when sheep are freely available, and could not have come as a surprise to the sheep ranchers. Fences were expensive but available. Who was most at fault? This is basically saying that if you don't lock the door to your house, it's your fault that the burglar breaks in, right? Prosecutors are not coyotes. They're not mindless, ruthless animals. They're people making choices. And when the prosecutors choose to be harsh, responsibility rests wholly and entirely with the human prosecutor making a decision. They are not animals, they are people. And this is a remarkably exculpatory quote for prosecutorial severity. I think also, as a practical matter, as empirical matter, it's actually also an incorrect description of prosecutorial behavior. The next slide has a quote from Bill Stuntz, the late Bill Stuntz. And in it, Bill Stuntz says, look, prosecutors are not like civil plaintiffs. They are not paid by the conviction with bonuses for each additional month the defendant spends in prison. That proposition leads to another. extra months in prison are not like marginal dollars in civil cases. Once the defendant's sentence has reached a level the prosecutor prefers, or if you like, the level that the local voters who elect her boss demand, adding more time offers no benefit to the prosecutor. Indeed, prosecutors may actually value extra prison time negatively. In criminal cases, one of the two parties is like a civil defendant. The defendant almost always prefers freedom to incarceration and less incarceration to more. The prosecutor's utility function, though, is much more complicated. I think this is the better take, right? Prosecutors, we don't necessarily have to view prosecutors as inherently ruthless people. They're much more complicated than that. And that suggests much more room to change how they act and what we can expect from them. So we've gone to the next slide. This in particular is a quote that I think we need to focus on. Changing hearts and minds of prosecutors one at a time is what can be called the bottom-up reform strategy reform, a combination of legal ethics curriculum and a course in empirical criminology to create what would be the reformers' perspectives, a better class of prosecutor in thousands of county criminal courts in the United States. To be honest, I find this quote kind of almost shocking, right? It's description of what the progressive prosecutor movement is doing and trying to do. It's a gross caricature of that. The progressive prosecutor movement is not about an extra ethics class and some empirical criminology, although as an empiricist, I'm completely in favor of that. It's about trying to understand the broken nature of prosecutor elections in this country, that we've allowed white suburbanites to elect prosecutors who then get to impose the law on poor Black and brown people in the cities. And it's about spending millions of dollars on get out the vote efforts and recruitment campaigns to find progressive prosecutors who resonate with the communities that are most impacted by both violent crime and by violent prosecution practices, and to allow them to have a louder voice at the polls to choose prosecutors who already reflect the desires that they have and that white suburbanites lack and that white suburbanites have been imposing on them for decades, right? This is not remotely what progressive prosecutor movement is about. And to see it, go on to the next slide. Click it one more time. So this is Cook County in Chicago, right? So this dot map to me is one of the most amazing census maps out there, right? And so every blue dot is a white person, every black dot is a Black person, every red dot is an Asian, every yellow dot is a Hispanic person. And so obviously you can see where Chicago ends and the rest of Cook County begins, right? Cook County is blue, Chicago is where all the diversity is. And historically, those blue suburbs had huge clout in choosing the DA who would then impose law on the city. And if you click it one more time, you'll see the election returns from when Kim Foxx ran against Anita Alvarez, one of the first big progressive prosecutor wins. Click it again. In Chicago, she won like 415,000 to 171,000. So 2.5 to 1 margin in Chicago. Click it one more time. In the rest of non-Cook County Chicago is like half that margin of victory, right? Those suburbs vote for the aggressive prosecutors. The cities vote for someone else. And in fact, in the last few weeks of the campaign, Anita Alvarez held 0 campaign events in the city of Chicago. Every single event was held in suburban Cook County because she knew that was where the punitive votes were, right? And so progressive prosecution is all about trying to mobilize these voters who have felt not just the burden of crime, but the burden of punishment, and allow them to be heard and to speak, right? And the hearts and minds, they're changed. They're there and they're angry and they're tired of being ignored. And it is about finding the candidates and mobilizing the voters and overcoming a media ecosystem that views the slightest error still in a very harsh, unforgiving kind of way, and trying to change the way we approach just the fundamental politics of punishment. It's not 2 new classes in a law school. It's something so much deeper and more profound. I would say, just for a matter of time, make sure I don't chew up too much of Bob's time, let's skip the next slide altogether. My basic point being the fact that states that have seen prosecutorial, well, so here, actually, let's stop here for 1 second. This is actually a good side point out. These are changes of prison populations by county. How many people is this county sending to prison in 2010 versus 2014? And what stands out here is that with a few exceptions, one being California, you really can't identify any state lines here, right? New York State didn't decarcerate. New York City did, right? Ohio didn't become more punitive, though it has. Just enough other counties and it did, right? You can't even find Minnesota on that map, right? It blurs into the Dakotas and into Wisconsin, right? To change this decarceration we've seen since 2010 outside of California, it is not a state level thing. It is a massive confluence of county level changes in decision making, right? And so the last point I make, so it's the next slide I want you to skip. I don't have time to go with that. So skip over this one, click, one more click. Now click again. So I would say this, look, We've had one realignment success, right? California. But on the progressive prosecution front, you have John Chisholm in Milwaukee, you have Kim Fox in Chicago, keep going. You have, there's about 10 of these, right? I thought I could click through them all fast myself, right? We have a whole host of progressive DAs from Boston and Philly, all of Northern Virginia, Orlando, Texas. You have Chesa Boudin in San Francisco. You have Eric Gonzalez in Brooklyn. Rachel Rollins in Boston. Right? It's actually succeeded. Right? Realignment is happening in one place, but the progressive movement is happening in counties all across America. And you might say, look, most of those are urban counties, and you're right. But the fact is, the 200 biggest DA offices process 65% of all felony cases. If you flip the big urban counties to something different, and they are changing, and they don't have to worry about the rural vote to do it, they just elect based on urban preferences, they can have a huge impact on what happens, right? And so I think it's important not to lose sight of just how there's a lot that can go wrong with the progressive DA movement. I'm not an uncritical proponent of it, but you can't dismiss it the way I think that Frank has. So this is my final slide, just to sort of wrap things up, right? Look, fixing the moral hazard problem is a good thing. We should do this, but it's not either or, it's both and, right? We can't fix it unless we fix the attitudinal problems that undergird it, or we will never pass these reforms and we'll subvert them when we can, right? And I think there's reason to be optimistic that we can, but I think we shouldn't lose sight of sort of, how important this attitudinal shift has to be for any fix to happen. So thank you for working through all my logistical problems with the PowerPoints here. And I look forward to hearing your questions after Bob's talk.
Thanks, John. If anybody does have questions for either of the panelists and you want to write them down on an index card and pass them to the aisle, I will share them. I think there's some people in the back who have the cards. We'll take questions at the end. Does Bob have slides or?
Can I be heard?
Yes, you may be heard.
Oh, that sounds like a parliamentary question. That was a technical question. No, I don't have slides.
Great.
Well, I'll begin. Thank you very much. My colleague, Professor Pfaff, of course, brings a social science and empiricist expertise to his remarks. I'm, and also, of course, a perspective on Frank's book, which is both very critical and very specific. I'm going to take a different approach in a number of ways. I'm not a social scientist. What I bring is an interest in what might be called the intellectual or cultural history of how we think about criminal justice, especially when social science, while tempting, doesn't give us all we want. I'm also, I consider myself an eminent scholarly specialist in the subdiscipline I will call Zimringology. I'll offer some generalizations about how Frank thinks about these matters, has generally thought about these matters, and will consider the value of his approach as a model for how we think about criminal justice. So I'm going to be less graphic and more general. Okay. Frank Zimring finds the world of criminal justice very mysterious in ways that are both alluring and frustrating, both depressing and oddly reassuring. He's a radical skeptic about what we can know or understand, and a somewhat different kind of skeptic about what follows in terms of our ability to change. Change what? Well, that depends on what we're trying to change, but change in the form of sustaining something or reversing something. Let me set the predicates by reference to some earlier work on a different but obviously related subject, and that is crime rates. In his 2006 book on the crime decline, Zimring acknowledges what he calls the natural appetite to explain events and the desire for a bottom line. But then he bluntly states that that book has no bottom line for both encouraging and discouraging reasons. The discouraging news he offered was that there was no one distinct cause, maybe no pairing or triplet of distinct causes, and alas, a multiplicity of leading indicators for the great crime decline of the 1990s. He ascribes the lack of clarity in our understanding to basically the limits of what empirical science can tell us, but also to the parochialism of people in various disciplines, and of course, the impossibility of controlled experiments. Thus, he casts doubt on many of the proffered explanations, the explanations that have been proffered in the early 2000s, from changes in the youth population to the legalization of abortion, to the increase in prisons, and so to changes in drug appetites, and so on. Too many things that some people credited for what happened in the 1990s also happened in the 1980s. Most important, maybe most surprisingly in that book, he says we can't be parochial geographically. We have to look at other nations. And here the most striking thing about the book in some ways was his comparison to Canada. Namely, Canada, a country proximate to us geographically, culturally, economically, and in so many ways, experienced pretty much the same degree of crime decline without any of the supposedly causal factors identified by other academics. So in that sense, there was something tragic, something discouraging, something troubling about his inferences from that crime decline. Now, he did later nod in the direction of sophisticated policing. His best guess, and this was in the second book on the subject, The City That Became Safe, the distinctive changes in police policy, even though they couldn't be empirically measured with any great precision, might indeed be the explanation. So he ends on a somewhat happy note there. But more broadly, he draws a happy conclusion from both these books that's twofold. First, we know a lot of causes of, or possible causes of the crime decline, and it's good if we don't expect too much from proving the percentile contributions of any of them, because we can rest assured that there are lots of positive things at work. Also, and he emphasizes this in his books on New York City, the great crime decline occurred without any very notable changes in the demographics, the economy, the social structure, even the degree of racism in New York City at the time. Now that's confounding, especially for those who would like to associate crime rates with specific social or demographic factors. But Frank manages to extract something optimistic out of it, namely that we may not have to bear the burden of changing things in the deep way that's always difficult if maybe other things happen or can be done that would alleviate the crime rates. Maybe it means miracles do happen. Maybe it means we can make a side bet on human creativity and resiliency. In any event, we know that the terrible crime rates were not hardwired. Okay? Now, let's turn to the prison question we have before us. Okay, as you all know, in 1991, Frank, with the help of his great co-author Gordon Hawkins, of course, turned his attention to another mystery: imprisonment rates. It's a profound and complex book, The Scale of Imprisonment, but in ridiculously simple nutshell, it contains a radical skepticism about what we can know. Causation, forget about it. We can't even really find correlation. None of the proffered explanations really match up with the facts at all. Now, fast forward then 20 plus years, and now we have not the scale of imprisonment in some general sense, and most obviously not the scale of imprisonment in a static, stable sense per country. Rather, we have the prison boom, or as Frank importantly emphasizes, the prison admissions boom. He then undertakes a kind of Zimring-esque style, a kind of dialectic, which I think is quite central to his work. Again, the idea that proffered explanations just can't really cut it. All the Tocquevillian explanations for why Americans love to punish, also, of course, why we have lots of crime, these are fine for international comparisons, but they can't explain a temporal change within the United States like a boom. Okay, we're reminded, of course, and this is something John Pfaff emphasized, that the national number is really the sum of 50 plus state numbers, and that, as he shows, differences and diversity among those should actually produce a bell-shaped curve. Well, is it a bell-shaped curve? It might be still a bell-shaped curve in terms of the actual statically measured rates of imprisonment at any one time among the states. And therefore, there's a kind of moderating force there. But it's not a bell-shaped curve. It's a uniform direction in terms of the increases in those rates during the prison boom period of 1970 going forward. It doesn't matter whether, as he puts it with some caricature, the state is represented by Joe Arpaio as the icon of law enforcement, or a progressive police leader like Patrick Murphy. The answer in all these places was more prison. More broadly, the things that might in theory cause the boom predated the boom and never changed much. Moreover, and of course this is a subject of much study, the perception that maybe the prison boom can be explained by crime rates certainly doesn't work very well. There are endless social science problems, which I'll defer on to people like John Pfaff and others, but Frank concludes, not without a fair amount of agreement in the social sciences, that crime rates can't explain the prison boom. Somewhat more cautiously, and he suggests that arrest rates can't really explain the prison boom. And they just don't hold up to regressions as explanations for prison admissions. Another possibility, of course, is emphases on particular types of crimes, but that again doesn't quite work. Whatever the type of crime, it seems, the answer was always more prison. Drugs are a very tempting exception for Frank. He certainly concedes, indeed shows a fair amount of evidence for the possibility that that the anomaly of drugs could explain a great deal in terms of an increase in the prison boom. Drugs are somewhat different from other crimes in all kinds of ways. The key, though, for him in explaining, or at least finessing, the question of crime, of drugs, though, is, of course, the role of the federal government. Namely, he treats it as a kind of exogenous force coming from a somewhat different place. Some generalized increases in the degree of federal regulation and the degree of federal policy, and the intrusion of federal drug crimes might itself explain the drug crimes areas' particular contribution to the prison boom. So although it's something of an exception, he doesn't think of it as a very strong exception. Frank emphasizes that the decentralization idea in American criminal justice is very, very salient here. Most obviously, of course, most prosecutions leading to most prison admissions come from local prosecutors. And I'll put aside the vast subject which John approached very thoughtfully about internalization and externalization. But Frank emphasizes that there's something visceral about the relationship between local prosecutors and local law enforcement and the populace. And therefore, mood changes about fear of crime, anger about certain kinds of antisocial behavior is likely to produce very, very striking effects when the controls are at the local level rather than at some abstracted national level. Yet here again, of course, he emphasizes that although the localization phenomenon can augment the effects of a change, it doesn't necessarily cause the change. Localization has been around for a long, long time. And if anything, the federal role, at least with respect to drug crimes, had gone up to some extent. I think an interesting example, I'll just give you one more of this Zimring-esque pessimism about our ability to understand things, comes from something that's rather mundane compared to other factors he talks about. And of course, mundaneness is, in a sense, and I'll get to this in a minute, going to be an important theme for him. He spends a little time talking about the role of prosecutorial scorekeeping. And this may bear to some extent on what John Pfaff talked about. But scorekeeping is basically a kind of managerial technique. It's somewhat parallel to the dramatic example of what we know about with policing. And as Frank points out, I guess it goes back to Henry Ford. Management analysis and accountability predate the phenomenon in prosecutors. If you look at business world generally, it came late to law enforcement and late to prosecutors. And there's an argument which he posits that perhaps the the scorekeeping, the accountability, say, to the county board of supervisors, or the accountability of lower prosecutors to higher prosecutors, might explain, an increase in decisions to recommend that convicts go to jail, to make charges that lead directly to jail, obviously then, leading to higher prison admissions. If you just follow the pages, it's 3 or so pages on that subject, it's very, very Zimring-esque, where Frank basically posits an explanation and talks himself out of it, and in large part because he doesn't see evidence that the scorecard idea really put much focus on sending people to prison. There were all kinds of factors involved, and it's just not really clear that it could have had that much effect. I commend that section to your attention because it's a low level of analysis. I mean, low in the sense of very close to the ground and somewhat obscured from public sight. It's to Frank's credit that he looks at something like this. It is also quite typical of Frank, again, that he basically talks himself out of that as a possible explanation. Now, the pessimism more broadly in the book is, of course, really the flip side of the optimism about the crime rates. Namely, he is dubious that we can undo what has been done. This may seem surprising. It's certainly surprising to the rather romantic-minded people, as he views them, who take the premise that the remarkable thing about the prison boom is that it is unbelievably large, was unpredicted, is recent, is in fact anomalous. Doesn't that mean that it is abnormal and we can get back to the normal? Frank isn't so sure. I won't spend time now on the passages where he goes through the numbers, but I commend them to your attention as well. And it has to do with a kind of pessimism about what can be done once a kind of original sin has occurred. Although he's dubious about finding any specific cause for the prison boom, any one specific provable cause, he knows that it was caused by a bunch of things. I'll get to that in a second. But the significance may not be the particular causes, but the effect in this case, and kind of the opposite of crime rates. Suddenly we have, first of all, a social investment in prisons, because one of the manifestations of the boom was, of course, prison construction. And, if you build it, they will come becomes a significant theme here. Second of all, once we put large numbers of people in prison, even independent of cost, it becomes socially much more difficult to let them out than to imagine a decision where we didn't put them in the first place. In that regard, when Frank looks at the numbers for the post-prison boom phase, which is the last few years really, we get to something that looks roughly like what Frank calls business as usual. Things have leveled off. That's good. They haven't gone back up on the whole. But if you take the rate of prison admissions now, which is obviously a lot lower than it was 10 or 20 years ago, it's still going to sustain an extremely high prison population for many, many years. And when Frank runs some projections about what it would take in terms of reductions in prison admissions or other forms of releasing people from prison in order to get us back to what we like to think of as the normal period, let's say up to the early 1970s, it's frankly hard to imagine that we're going to do it. Where does this lead him in terms of pessimism and optimism? The book gets back to something that's discussed at length in the crime decline books, namely what Frank calls, and he doesn't use the terminology here again, I believe, but I'm going to connect the two anyway, to triangulation of proof. And now, in those crime decline books, he emphasized the idea, borrowed from Professor Blumstein and others, that we have only imperfect measures of things. We're never going to get a perfect one. So maybe what we should do is sort of crowdsource the imperfect methods. They don't wind up reducing each other's ineffectiveness. I'll do some crude arithmetic here. They add, they don't multiply the numbers below one. We make a bet on imperfect methods, perhaps telling us something that might be useful, especially when we just look at really dramatic correlations, even if we can prove causation, changes in sophisticated policing being the main thing. In terms of unwinding the prison boom, he then refers to things which he thinks, which he would acknowledge are rather mundane. Obviously, there is the possibility of sentencing commissions. I know Professor Fraser will talk about that more. There are possibilities of changes in internalization and externalization or incentives and so on. And obviously, John Pfaff has cast a fair amount of doubt on that. There's a fair emphasis on a side bet about jails because, of course, number one, well, if you're just looking at prison population, which is what we did at one point in California, then of course, gee, we can get them out of the prisons and put them into jails. But of course, the story of California is that a shift then goes to jails. By the way, just a quick point, I'll respectfully disagree with Professor Pfaff on this point. If the increase in jails ate up 1/3 of the reductions in prison, well, we've got a 2/3 full cup, a 1/3 empty cup, or something like that. I won't get out of this metaphor very well, but the point is that it's really not such a bad outcome. Any number of things are mentioned by Frank at that point in terms of, as I said, commission changes, bail reform, and so on and so on. I don't think he claims, of course, and in fact, he very clearly does not claim that he can project in any accurate way that these will reverse the prison boom. I think he views them as mitigating effects, but I think he makes kind of a side bet that there will be some resiliency that we won't fully understand, but will come to appreciate. And in that sense, this is kind of the mirror image of, although a much less reassuring version of the happy story from the crime decline. And I'll stop there. Thank you.
All right. Thank you to both John and Bob for sharing their viewpoints with us. I'm going to artificially limit us to 3 questions here to make sure everybody has a chance to refresh and take a break over the lunch hour. And I do have 3 questions in the queue, so that eliminates the burden on the studio audience here unless someone wants to force their way in. The first question, John, I think is for you because the questioner believed you had some familiarity with this topic. The question is, Danielle Sered's work on restorative practices and violent offenses and her book, Until We Reckon, are groundbreaking. The question is, how do we change the culture in the system to incorporate this work?
Yeah, I mean, it's a fantastic question, and I completely agree with the questioner saying that what she's doing is revolutionary and transformative. And I think it's important to put in context how important it is. Currently, 55% of all people in prisons are in for a violent crime. In fact, fully 1/4 of the entire U.S. prison population is in for murder, manslaughter, or rape. That's it. That's 25%. That population alone is one of the world's largest incarceration rates there is. Right? So unless we're willing to talk very seriously about violence, we will always be the world's largest jailer. Where I get hope, and so the idea behind, for those who are unfamiliar with it, the idea behind Danielle Sered's work is she runs this group called Common Justice in New York, in Brooklyn, and the engagement is called restorative justice, which is the idea of instead of like really penal, in a punitive, penal way, punishing the person who causes harm, you bring the person who's injured, the injurer, and other community people together to help the injurer take responsibility for his or her actions and help them work together to figure out what is necessary for the person who's injured to feel somehow restored. And remember, when Common Justice first came out, I just moved to New York. I saw Danielle give a talk when they were just spinning off the group, and someone asked her, like, "This is great for low-level stuff, but you'll never be able to do like homicide with this." And at that point, 10, 15 years ago, Danielle said, "Look, the then Brooklyn DA Joe Hines, who's actually one perhaps the most progressive DA Brooklyn's had in a long time, was actually willing to tolerate doing a homicide case, but they decided it was too risky early on to do that. But now they focus exclusively on basically murder, manslaughter, aggravated assault, and robbery. They don't do sexual assault and rape, not because she thinks it's inapplicable, but because it requires different training. It's a different category of offense. So it really is a transformative way of approaching the most serious and the most devastating crimes. And so how do we get this to happen? Well, Brooklyn's a great example of that. if you let the people closest to the problem have a say, you get radically different outcomes. One of the striking, so the way it works in Brooklyn is that first a DA has to sign off. I will let this case go into a restorative justice format. If the DA signs off, it then goes to the victim. And the victim then gets this, or the victim's family then gets to decide if they want to do restorative justice. And they say yes, then this process moves forward. Of the cases that the DA allows to go forward, and that's not a random sample, 90, not 19, 90% opt in to common justice. They opt out of the punitive system into the restorative. And it's not necessarily out of some deep abiding love of the injurer. It's a pragmatic view of what does and doesn't work. Danielle talked about this one woman, this one mother whose son was the victim of a violent assault. The man was arrested, he's gonna go to prison, but not indefinitely. And she said her first reaction was that she wanted to set this man on fire. And her second reaction is that she wanted to drown him in a freezing lake. And then she settled on she would be happy just to drown him in a river of fire. That was her compromise. Yet, when given the option between straight up punishment to this typical prison system or common justice, she chose common justice because she said, look, he's coming home and my kid's still alive. And I have a younger son. And I've seen what prison does to people, and they come back to our community. They leave here, they come back here, and they victimize us again because they themselves have been re-traumatized and unhelped in prison. And your program seems to work. The reoffense rate is stunningly low. I want in, right? And so if you let the people who really see what doesn't work, for whom crime is a lived daily experience, not some sort of abstract theoretical concept, the more voice you give them, I think the more realistic a set of policies and choices you're going to get.
Thank you. The next question is for Bob. Bob, you touched briefly on the concept of bail reform in your discussion, and the questioner wanted to know if you could talk a little bit more about your views on the role of bail reform in reducing incarceration, either in terms of your own views or commenting on Professor Zimring's approach to that topic.
Frank talks about bail reform largely in the context of what he thinks of jails. And so I put the two together. Bail reform, by the way, is pretty active in California, happening on all kinds of fronts. There was legislation to eliminate cash bail, well, that got held up. There were various lawsuits that didn't call for the elimination of cash bail, but elimination of detention on the basis of inability to pay. So obviously, dramatic adjustments in the amounts of bail and other things as well. It's a very complicated story. First, just on the bail point, the law that was enacted, although delayed in California, actually proved to be very, very controversial. And there was a fair amount of buyer's remorse from some reform groups because they were concerned that we were just transferring power back to judges to engage in discretion and who would then simply detain a lot of people where cash bail was simply irrelevant. In terms of jails are extremely crowded all over the country because of pretrial detainees. And California happens to have, I think, the highest percentage of people who are in jail who are there pretrial. This really confounds the role of jails because those people, first of all, represent a chaotic inflow and outflow that you don't have in prisons. And therefore, the likelihood of anything useful happening for them while they're there is extremely small. Frank adds the fact, and this is something I think I'd like to look into further, that precisely because the people who are in pretrial are going to be charged with crimes that are much more severe than the crimes for which the post-trial jail inmates are serving time. Those are obviously going to be lesser crimes. The physical structure of jails is disproportionately allocated to guess what, high security. Because there are some pretty dangerous people who haven't been convicted of their violent felonies yet, although they probably will be. And that leads to problems of the fungibility of space. That's a problem that Frank talks about with respect to prisons as well in terms of supermax prisons. Bail reform is going to happen in the United States. I think more people are going to get out. There's going to be more emphasis on algorithms, on pretrial services. What effect that will have on jail populations is hard to say because, of course, it could simply release space and there could be more California-type policies where people previously sent to prison will go to jail. The fungibility of space issue is another thing. So I wish I could say something dramatically insightful about that. But all I'm going to say is it's messy.
Final question for either panelist. This has sort of a premise and then a question. The premise is local governments can finance infrastructure like prison construction by bonding, but operational expenses like intervention and therapeutic approaches must be funded by existing revenue. The question, would it be a viable idea if local governments could issue bonds to pay for operational revenue like treatment?
I'll defer to my economist colleague. Economics question.
I haven't been, I haven't been an economist now probably in about 20 years. I mean, it's a good question. It's a question I've thought nothing about. I guess in an effort to spin it to something I have something vaguely useful to say. I think it's a good indication of how many problems operate in incredibly subtle and invisible ways, right? And in many ways, that is the great thing I think about Frank's book and about drawing attention to this moral hazard problem. I mean, this moral hazard problem has existed for years, and Frank's not the first person to talk about it, but he's one of the few, right? When Bill Stuntz talked about it in his great final book, he admitted he's basically the second person to talk about it, and the last one had been someone who brought up in 1990 and got forgotten, right? Like, because it's boring, right? We all want to talk about the flashy, fancy stuff, right? Let's talk about the capital cases and drug offenses that get you 50 years in prison. But, you know, death row is 0.05% of the system, and only the feds in Louisiana give 50-year sentences for drugs, right? What really drives the system are the really invisible, pernicious things that remain invisible and pernicious because they're boring to talk about, right? Intergovernmental budgetary transfers, which is basically what Frank's book is saying we should target, is incredibly important and incredibly boring, right? And the fact that capital infrastructure comes out of bonds and operating expenditure has to come out of current revenue. Again, and I say this as someone with a PhD in economics, that's boring, right? But incredibly important, right? And it's because of, and that is so much of how the system fails us, is because we don't understand these incredibly subtle things that really matter. And I've long said that if we want to really solve criminal justice issues from a policy side, our greatest hero is Leslie Knope, right? From Parks and Rec, right? Someone who never wanted anything more than to sit through a county level budget meeting, right? Like that's so much persists there. And so I think that question, which I don't have a great response to, could it work? Maybe, right? It could be lots of ways to go south too, in ways I haven't begun to think about. But I think it's a great way of reminding everybody. And this is, I think, you know, I know I was fairly critical, but this is, I think, the great strength of Frank's book, is that to remember a lot of what's wrong is the incoherent way our systems cobbled together, right? I never let my students talk about a criminal justice system. I never let them use it in the singular. I always make them talk about it in the plural, systems. So they appreciate that it's city police and county DAs and state prisons and county jails and state parole, but different state parole than the state legislature. One's the governor, one's local officials, right? It's debt for buildings, but operational revenue for the doctors who have to actually run the programs in the buildings, right? And it's, I think that's a great way to remind us, and I think a great testament to sort of what Frank is trying to accomplish in this book here, to keep our eyes focused on these kind of, you know, really nitty gritty, easily overlooked, not fun to talk about at cocktail parties things that end up being so bad and harmful because they're not fun to talk about at cocktail parties.
If I can be spared 1 minute to add a point. And I don't claim to understand bond financing very well, but it's associated with what I've called the theological imperative of criminal justice in the United States, or criminal justice systems, just to obey John there, until recent years. That is to say, it hid a lot of the costs to the taxpayers, delayed them, did all kinds of things. That was okay because, of course, criminal justice wasn't a government program subject to rational cost benefit analysis, you know, for many years, at least in the view of many people. It was a theological imperative, okay? And through sentencing commissions and other mechanisms and conferences like this, we've gotten to the point finally where we can think of it as a government regulatory program subject to cost benefit analysis. Now, I just find it really provocative to think that the bond financing would be used for treatment of various kinds, because it might be that that would become a theological imperative rather than prison construction, and connecting to something which is both tragic and poignant and in a weird way optimistic in Frank's book, The Opioid Crisis, where he emphasizes that if we change our drug policy now, it isn't going to be because we've changed our view about how dangerous drugs are. Quite the opposite. If anything, we now view drugs as much more dangerous than we did before, but we're talking about opioids. And of course, we're talking about drugs that affect or injure a far wider range of people, and frankly, far more white people. The effect of this might be decriminalizing drugs, and I don't mean in the usual sense of decriminalizing marijuana, but rethinking drug policy by getting it out of the drug area. And it would be really interesting if that became a theological imperative, as evidenced by using bond financing. Thus endeth my discourse on a subject I don't even have a PhD in.
Can we have a round of applause for our panelists? Thank you for joining us and sharing your knowledge. Good luck at the doctor's office, John, and Bob, good luck with whatever else the day holds for you. We're now going to take a 10-minute...
Thank you very much, everyone.
Thank you.